Yes,
Take
tell
it
me.
I take to mention item number 4. Daily thing.
Hmm.
But on the last occasion, your daughter was pleased to grant me some time. File an IA. But today, my lord, only the FO. I filed the IA. The FO came up with I did not get it.
The request of the learned counsel for the petition appellant matters sent on offense with 4th of April.
File your.
I beg to mention on CRPI of policy on Monday.
Item for 24 order matter. The IA has been listed, but the IA is the content of it.
Yes, what do you want?
My file has been misplaced. Matter may kindly list after vacation immediately.
84 after.
Highly obliged. Highly obliged.
Your Lordship, the petitioner come before your Lordship, as your Lordship, her husband, your Lordship, has filed one FC civil case number 612/22 against the petitioner before the learned Principal Judge Family Court at Guwahati, praying for restitution of marriage. And notice was served accordingly to the petitioner, your Lordship, on dated 28/6/2022, that I have annexed on page number 36 onwards, 36 to 42.
Yes, what is the difficulty?
Your Lordship, she has having 3.5 years old daughter, your Lordship.
3.5?
5 years old daughter, your Lordship.
So?
Your Lordship, she cannot travel from Nagaon to Guwahati, your Lordship, leaving her child, your Lordship. So kindly.
To go and tell the court that look here, this is the problem out there. Kindly give me virtual hearing if it is necessary. Virtual is permissible.
What is this? Transfer to the original jurisdiction, your Lordship, where the matrimonial DP case is going on, your Lordship. That is
matrimonial, some cases going on.
Your
Where?
Lordship, as SDGM, your Lordship.
Where?
Your Lordship, I have annexed it. As
Nagaon.
Annexure 1 and your Lordship. Page 934 as annexure 1.
And what do you do? What do you do?
Lordship, she has no issue, your Lordship, for restitution. She is also appearing before the SDGF, your Lordship, now.
You want to contest the restitution?
Your Lordship, yes, your Lordship.
Why? You don't want to go with him?
Your Lordship, she wants to go because
then go.
there is like traveling difficulties.
Go and compromise.
Your Lordship.
That okay, I'm going to go. One day you have to come instead of filing so many cases.
Escape, your Lordship, saying that she is single-handedly raising the child, your Lordship. Only 3,000 has been given to her, and your Lordship, till date, your Lordship, no maintenance has been provided. I have mentioned it in paragraph 6, your Lordship, that is page 5. Your Lordship, on date 1/8/2023, an amount of rupees 3,000 given, which she has been received, and then date on 7/1/2024, an amount of rupees 5,000 due to non-payment of the interim earlier maintenance, your Lordship, that has been fined, your Lordship, and 2,000 extra has been given. So, your Lordship, it was quite difficult for her to come, your Lordship. So,
why? No money. Notice.
Notice me.
What is the next date?
28.
Of? No stay. We'll issue notice. Let the other side come.
Yes.
We'll give you 3,500. Come over to go. Issue notice upon the response, making it returnable on 13/5/2015. Steps be taken by way of registered post as well as AD. The petitioner is further directed to take steps by way of the stick rooted to the raised bed and file an affidavit of service on or before the next date. This court have asked the learned counsel if it had inquired with the learned counsel appearing on behalf of the petitioner as to what is the next date fixed in FC Civil Case number 612/2022 pending before the Court of the Principal Judge, Family Court at Guwahati. The learned counsel submitted that the next date is on 28/5/2024. Taking into account the above, this court for the present is not granting any interim order. Further, if any orders are required at a later stage, the same shall be considered on the next return.
Deeply object.
Yes, what is
It
this?
is your lordship, there is a ex parte degree of the suit lordship. Because I filed a title suit for specific performance of agreement lodged, which they have not executed in spite of almost the entire amount was paid lodged. Thereafter, they appeared in the title suit, filed the written, they did not file the written statement. Once they filed the written statement, and they also come for setting aside of the ex parte order, but they did not move it, and later on the ex parte decree was passed out. Thereafter, I filed an execution lordship.
Who filed?
I
Then?
being the degree holder. Yes, lordship. On the last occasion when the matter was fixed, this was fixed for filing of the draft sale deed lordship. But on that day, particular lordship, though it was prepared lordship, some technical error crept in my laptop. That's why I could not get the printout, but I filed a hazira with a statement that this will be filed during the course of the day. Lordship, when I reached the court, it was almost 4 o'clock. And by that time, Lordship, the order was passed dismissing my.
We dispose it of
Yes, Lord.
unnecessary, and it was ex parte only, no?
It's an ex parte, Lordship. Only for
And what
filing.
is this type of filing an application under 151? What is this? Tell me, what is this 151 application here? Therefore, this is an application under section 115
Type where
of the Code of Civil Procedure, 1908, challenging the order dated 9/1/2024, passed by the Civil Judge Senior Division, come Assistant Session Judge, passed by the Civil Judge Senior Division, number 3, Kamrup Metro at Guwahati, entitled Execution Case number 51/2022. Did you submit an application? Anything? Well, one thing arises. This is section 28. So if the court gives you a time and you don't file it, your right to court may reject it.
Lordship, but I explained Lordship the reason.
That's
But-
good, but anyway, I can't help it. I think the notice has to be issued. Where is your Hazira?
Lordship, Hadira, that I have not annexed. Lordship may call for the record also, Lord. If your Lordship is a
Why should I call for the record?
or Lordship, kindly allow me the matter be taken up immediately after the 2 holidays. I shall obtain all the certificates and place the
Madam, let me tell you one
Lord-
thing very
Lord-
clear. You better withdraw this petition and file a fresh. Why I am saying it is,
Lordship.
the moment I issue a notice,
Lordship.
they will come up, what is this 151 business?
Lordship, this is typo error, Lord.
This is not a typo error business. You can't file 151 for this in the High Court.
Lordship.
Huh? I remember this matter.
100.
There was a matter pertaining to PMLA. That PMLA matter, what was happening in PMLA 120B is a schedule of it. Now, any case, therefore, 120 is criminal conspiracy. So, any case, you can just bring in 120B and invoke one PMLA. No matter went to the Supreme Court. The Supreme Court says no. Unless you have a particular offense on the basis of which 120B can survive, you cannot have 120B alone.
Yes, the basic fact.
Same is 151.
That's what I was discussing with him. Directly under 150, nobody can come. Particularly when you are
151, if you
division.
come directly, you don't have the. How will this court exercise jurisdiction?
Lordship,
You better withdraw this and file a fresh one
Lordship, that.
and bring on record that hazira,
I,
because that is
I-
required.
yes, Lord.
The learned counsel appearing on behalf of the petitioner submits that there are certain formal defects in the petition for which she may be permitted to withdraw the instant application and with the liberty to refile. Taking into account the above, the instant petition stands closed on withdrawal. However, liberty is given to the petitioner to refile by removing those formal defects. In fact, the impugn order is also not typed. How did it pass? Yes, you filed an IA.
I filed my
What happened? Any correction you could do it in that matter?
one. I've come up with one that
Hmm.
which says even if there is a stay of the suit, the court can proceed.
98.
My lord,
98.
my lord. That Indian Bank. And there are two other High Court cases where, my lord, there was a revision pending before the High Court, and the High
But that
Court,
is in respect to section 10.
there is one is in respect of Section 10. The other one is what the Lord is indicating 90 is
98th question came in as regards if there is a proceeding state
Yeah.
in view of section 10.
Yeah.
Can the court proceed in respect to the interlocutory proceedings?
Yeah.
The Supreme Court said yes, because that has nothing to do with the trial.
and court will not proceed on the merit of the case, but then for injunction, for attachment for judgment, for preserving the property. Okay. And here is the case, my lord, I am not asking for any order which will touch on the merit of the case. I am on this basically, although we have filed a order pertaining to court, saying for setting aside, our basic intention and prayer is that I be allowed to exercise the right which I am otherwise entitled. And the prayer of the plaintiff was to restrain me from selling the shares. I don't want any order that I be allowed to sell the shares. What I want is
You want to exercise the right.
my lord. And by status quo, actually, I was not prevented from exercising my right, but the banks are not, the company is not allowing me. They are saying that the status quo order. That is why, my lord, I want basically a clarification. And which I have very clearly, my lord, stated in for present IAO.
Now, if it is a question of clarification, would it come within the ambit of Order 39, Rule
My
4?
lord, it says varying the order. So we basically want by varying the order.
Varying is different from clarification.
And varying is necessary because, my lord,
Understood. I understand. But you are asking for a clarification. That's look here, the letter order remain. But I should be, and I am not being entitled, given the entitlement to use those shares.
doctor is technically correct, but I have no other way. That's why I paid for setting aside, because if by varying the order, the court says that although it's a status quo, you are not prevented from exercising your right as a shareholder. Otherwise, I am entitled to exercise that.
And what is the other application for? The application you have filed for?
IA, my lord.
For?
IA is for my basically order 13 rule 4 here.
How is one Order 39 Rule 4 is there you are challenging a particular order. How are you applying Order 39 Rule 4 if I don't have an application? I have not passed an injunction.
Why it against the rejection?
Understood. But I have not passed any injunction. What do I do with this?
I have added 151 here.
Hmm?
I have added 151 here. But still not can invoke 150. The period will come. But I can file an for under what certain one.
And what is this pending disposal of the application? You want an injunction?
Different. Basically, I wanted some order.
Mr. Mazumdar, this matter is a very highly contested.
I'm very
So
conscious.
under such circumstances, moment I issue notice, we'll have a host of Calcutta law.
Yes, I'm very much conscious of that.
So you need to
I'm
be very,
very careful.
very careful.
Right.
Small things, they will just
They will take, right?
okay, then we'll do one thing. We admit the appeal and issue notice here. And I say that you don't want to press the prayer for pen. And if necessary, you will file an application.
Right.
I think that is a
Well,
way out.
Let them come here. I also pray that any order passed, let be the presence of judge.
But you need to do something with that. CRP, whatever happened,
Fine.
you may ask for clarification or something to that effect, a review to that effect. In view of more particularly, see, I don't understand. If he is asking for probate, is he not intermingling with the estate of the deceased? If he is doing so, then he can very well participate. You can't stay till the probate is granted. The probate has no relation out here. But he is a legal representative, he is a party, so you can help to proceed. That is, so far I could understand. See the meaning of legal representative? Section 219, 219 or 319, whatever may be.
Another aspect is there. The additive temporary injunction was granted at a time when the plaintiff was alive. Now, subsequently, when the plaintiff has expired, subsequently has not taken place till now. Now, the additive injunction order is working inclusive, cannot work in favor of any person. And if there is no beneficiary of the order, how the order can be enforced by
Very well made argument. But for that, you need a order 41.5.
I was just yesterday when we were discussing whether this
Then I understand, but see the meaning out here.
means the person who in law represents the estate of a deceased person,
Not only that, then
and in any person who intermediary
with the estate. So this, he will be the legal representative because he is asking for a probate. He is intermingling with the estate of the deceased. So under such circumstances, why the suit should not proceed in view of the definition given?
And I have seen that there are cases where it says if a person is proceeding and probate is yet to be granted, suit will proceed, but the decree will not be passed. At the time of decree, he must have a probate. So in that the matter is that
In fact, that is what I don't understand why the suit is not proceeding.
Yeah. difficult is matter. At that time, there was an order. They came before the court. Court also upheld the order.
Hmm.
Nothing happened.
No, in fact,
So far as abatement is concerned, my lord, I
don't you think that you need to challenge the stay
Yes.
of the suit?
well, difficult to say if against that it came earlier. We were not there. So they also filed a petition. We also filed both ways. By this,
Think about a good ingenious idea what to do.
Fine. I'm thinking file a review. Review.
Review would be too delayed, and by the time it finishes, you will be in more trouble.
And there was one more way out, man. Since the plaintiff died, there was
Where is that order passed by this court?
page 117.
117. What is this? After packing of this, what is this page? 117, 1120. What is my opinion? Paragraph 20 is wrong.
20. I've just 20. Not be correct.
Absolutely. Because that is without going into what is the legal meaning. I think many Supreme Court judgments
Yes,
are there on this 219.
Both are very
Anyway, appeal is admitted. Issue notice, make it returnable by 15/5/2024. Step be taken by way of registered as well as usual. Further to that, the petitioner is directed to take steps. The appellant is directed to take steps by way of dusty. Take a step by the routed through the registry of this court and file an affidavit of service on or before the I to issue notice. So, again, notice returnable event. Yeah, dusty. That follows the Mr. D. Mojumdar Learned Counsel appearing on behalf of the appellant. Applicant submits that that inadvertently in the instant application there is a relief sought for, an interim relief which has been sought for, which which cannot be permitted in an application, which ought to have been sought for by way of a separate application. He therefore submits that the said interim order, interim reliefs which have been sought for, he therefore submits that the applicant would not press for the said interim relief which have been sought for in the instant application. However, the same should not preclude the applicant to file an appropriate application seeking the said relief. Taking into account the above, the interim relief which have been sought for in the instant application stands withdrawn. However, liberty would be there to the applicant to file appropriate application in
As a dependent of the
else you are in again this aspect will make another problem.
Well, as a dependent also I can file order pertinent to one.
Huh?
The dependent also I can file order pertinent to one.
Yeah.
Think over it. And record say court.
Record why?
But
Record's not necessary. It's an FAO. Why we need the record? You can't help it unless you think about something to do with that.
Fine.
Justice in your judgment.
May I please your lord.
You are for the respondent or the plaintiff?
Petitioner lordship.
Hmm.
Other side, lordship,
You are
they
the
have filed
petitioner.
a stay petition, lordship.
Huh?
Stay petition.
No. Your application. You are the petitioner. Come to this side. But they have filed some stay vacating. No.
Stay vacant petition.
Where? Hasn't it? Stay vacating. Can't be stay. Yes, what is your case? You are challenging what order?
Lordship,
What is the order you are challenging? 17/8/2023. Where is that? You are the decree holder or the judgment debtor?
judgment debtor. Lordship. Order dated 17/8/2023, lordship, page 57, lord.
So what is wrong with the order?
Lordship, first of all, lordship, whatever money amount is written here, lordship, that is 13,98,000. Absolutely, I have not received, lord.
Huh?
I have not received.
What you have not received?
That amount is not received by me, lord.
That is a question of trial. The trial. The trial has already been done. It is at the stage of execution.
Now,
Whether you have got the money is immaterial. The trial court has come to a finding that you are liable to pay this 13 lakh something.
98.
Yeah.
And Lordship, now the learned court below Lordship
Hmm.
passed the order deducting amount of rupees 30,000 from my salary, Lord.
Hmm.
Whereas I am drawing altogether salary of 40,000, Lord.
40,000.
40,000, Lord.
What do you do?
Lordship, master role, laborer.
Huh?
Master role, laborer.
Then
Lord, now, Lordship, there is a deduction that I have taken the loan from the bank, State Bank of India, where deduction is going on 17,274, Lord.
Hmm.
And also, Lordship, besides that, Lordship, is my wife is a cancer patient. And also, I have a daughter.
so how are you going to pay the decree? How are you going to pay the decree? There is a decree. Either you go to the jail, civil prison. You want to go there. Very well. We don't allow. Let the entire money go to your wife. Let her be satisfied. The loan be defrayed. Everything. You go and stay in the jail. He's going to pay you. Go to the jail. Civil imprisonment. Very well.
Lordship,
We do this thing. We interfere with this order. Okay, no dispersal. That he is ready to be sent to the jail. Civil imprisonment. Fantastic.
Lordship, this dispute is not between me and my wife, Lord. It is a land dispute, Lord. Land dispute.
Let's see the decree. In the result, of the suit of the plaintiff succeeds and the same is decreed with cost. The plaintiff is entitled to get back 4,50,000 along with interest at 18% from the date of the payment and the said money till realization of the decree. Apart from that, then you have taken that amount of rupees 4,50,000 and now can you go away? And see additional issue, page 43. Whether the plaintiff is entitled to 4,50,000 along with interest from the date of payment of the money till realization if found that plaintiff is not entitled to a decree for specific performance. You have taken that money and now you are saying all these things. This decree is final. You are liable to pay this 13 lakh so and so. I don't see any wrong in that order. Else you want to go to civil prison? Let me find it, the provision. You go. What is there? If you don't have money, what is this world to live in? Better that money goes to your wife. She requires treatment. You go to civil prison. Yes, civil prison is with provision to send you. Let us see. Better go to civil prison. You have entered into an agreement for sale. You sold off the land to somebody else. You can't take money from people and then forget about. Every person detained in civil prison in execution shall be so detained where the decree is for payment of money exceeding 5,000 for a period not less than, not exceeding 3 months. Money is for, where the decree is for payment of money, sum of money exceeding 2,000 rupees, not exceeding, the money is for 6, provided he shall be released from such debt before the expiry on the amount being paid. Okay, at least go and stay there for in the jail for 3 months.
Lordship, in the courtship, Lordship, it has come as stay vacant petition.
No. If the causeless it comes, whenever there is a stay, it comes that matters where there is a stay. So today it has to come to an end. The end is you go to jail.
Lordship, I am in impression, Lordship.
Huh?
Yeah, Lordship, I am in impression that as it has
Don't
stay
be in an impression.
As
It is,
stay vacate
Mr.
petition is there,
Sharma,
but
is it the first time you are appearing in this court? So under such circumstances, you know the manner in which the court works. One. Two, is it the first time you are taking up a civil bench one matter? No. The civil bench one matters clearly say that there is a column where wherever there is a stay, the matter comes up. It is not for stay vacating, where stay is there. So this is why the matter has come. Otherwise, what happens here? Now tell me, what is wrong?
What?
Earlier judge was good.
Lordship,
I am not so good.
Lordship, I will satisfy before your Lordship.
I am not
Lordship,
satisfied.
Lordship, after vacation.
Okay, I am vacating the stay. Then it won't come.
Lordship is 10,000 rupees.
No,
I am
10,000 is too meager. What property you have? What property you have?
Only that home.
When
property I
that- you have a home.
Other
File an affidavit of assets on the next day. That is the ground.
Lord.
If you don't have any property, you then go to civil prison. Pack your bags properly. Okay. Civil prison, one thing is good, the other side will feed you, give you the food. Don't need to spend the money. Okay. We'll having it on 22nd of April.
Lord.
Immediately. Where do you stay? In Guwahati?
Lordship.
Huh?
Guwahati, Lord.
Okay. Then in Guwahati, let's have it on 22nd. List the matter. This court, upon hearing the matter at length, is of the opinion that the grounds assigned for not making payment, grounds assigned for is prima facie of the opinion that the grounds assigned in the instant application under Article 227 of the Constitution are not reasonable or just grounds for interfering with the interim impugned order. Mr. R. Sharma, the learned counsel appearing on behalf of the petitioner, submits that the petitioner has his residence, owns a residence. But under such circumstances, he submits that he will file an affidavit of assets in terms with Order 21, Rule 41 of the Code of Civil Procedure 1908 on the next day. List the matter on 22/4/2024. The affidavit of assets has to be filed on or before 20/4/2024. Interim order passed earlier shall continue till the next date.
Lordship, the senior legal counsel stuck on the traffic.
Who?
Senior legal counsel M. Talukar.
What happened?
So, sir, he have told me to take the if Mahabal pray from my life, if matter can be taken a second.
Huh?
The second.
Taking into account that in pursuance to the order passed by this court, steps have been taken and the trustee has been affected here. On the next day, if the area is not where the court shall notice. Oh, I'll allow your petition. Why do you need Mr. M. Talukar? First, button your court. You don't appear in the court in this matter. Yes, now. Yes, tell me your name.
My name Karthopin Datta.
When heard Mr. Swento, the learned counsel appearing on behalf of the petition. The instant application is filed challenging the order dated 13/12/2023 passed in passed in passed in Ms. J case number 238/2023 arising out of title appeal number 4/2018 by the Court of the Civil Judge Senior Division at Amingaon, Kamrup. From the materials on record, it reveals, yes, Mr. Taluga, I am allowing your petition. You have any problem? From a perusal of the petition, it reveals that an application was filed under Order 41, Rule 25. Read with Section 151 for framing additional issues before hearing of the said appeal. From a perusal of the said, application, which have been registered as Ms. J case number 238/2022. The additional issue which was sought for to be framed is as to, invert comma, whether the suit is bad for misjoinder and non-joinder of necessary parties, whether the suit, whether the said suit there is misjoinder and non-joinder of necessary parties and liable to be dismissed the said suit. This application, to the said application, the respondents herein filed objections. The learned first appellate court rejected the said application by the impugned order holding inter alia that the pleadings of the petitioner, the pleadings of the appellant, who are the defendant, the pleadings of the petitioners herein, who were the appellants in the said appeal, did not in any way raise a pertinent question of law or fact regarding the suit being bad for non-joinder or misjoinder of necessary parties. The learned first appellate court also opined that the court had gone through the evidence led by the party and even after perusal of the evidence as per the learned first appellate court, framing of issues regarding suit for being bad for misjoinder and non-joinder of necessary parties is not necessary. Accordingly, the said application was rejected and the title appeal thereupon was fixed for being heard on merits. You filed the appeal.
Yes, madam. Madam, what happened actually, there is a
Don't come to many opinion. I'm asking you, did you file the appeal?
Yes, madam.
You have a memo of appeal?
Yeah.
Give it to me. Memo of the
Madam, here, defendants are residing in a different village.
No, your only additional issue you wanted,
Yes.
that whether non-joinder or misjoinder. That's all.
Entire case, entire should rest on this issue. Yes. Yes, 70.
Huh?
Yes,
Page 70.
77. Excel.
Where is the ground of objection? That of necessary party? Here. देखो. This court, pursuant to filing of the instant petition, issued notice and further state the proceedings entitled Appeal number 4/2018 till the next date. The record reveals that the service have been duly effected upon the respondents through Dusty. Which aspect have been duly recorded in the order dated 27/3/2024. In spite of that, the respondents did not care to appear. Under such circumstances, this court takes up the instant proceedings for disposal at this stage. This court have duly heard Mr. M. Talukdar, the learned counsel appearing on behalf of the appellant. A petitioner who submitted that against the judgment and decree that submitted that the instant appeal is against the judgment and decree submitted that the title appeal number 4/2018 is directed against the judgment and decree dated 11/1/2018, passed in title suit number 283/2014. In the same, in the pleadings, in the written statement filed in the suit, by the petitioner, a specific preliminary objection was taken as regards the maintainability of the suit at paragraph number 3 on the ground of misjoinder and non-joinder of parties. Though that aspect, that preliminary objection so taken was not framed as an issue in the trial court. Which is one of the grounds taken in terms with section 105 of the Code of Civil Procedure. As would be seen from the ground of objection number 5 in the memo of appeal filed in title appeal number 4/2018. He therefore submitted that this aspect as regard non-joinder, misjoinder and non-joinder of parties ought to have been taken into consideration by the learned First Appellate Court while adjudicating the appeal. Or the learned First Appellate Court, taking into account that the said issue was not framed, ought to have remanded the appeal, ought to have exercised the powers under Order 41, Rule 25 to remand the suit by framing that specific question as issue for decision. It is under such circumstances the application was filed, which was registered and numbered as Ms. case number 238/2022. The Learned Counsel submitted that this application, although the Learned Counsel further submitted that although the said objection was filed, so although written objection was filed, but the application under Order 41, Rule 25 could not have been taken for decision prior to deciding the appeal, inasmuch as the said application had to be decided along with the appeal. And therefore, a gross illegality has been committed on behalf of by the learned First Appellate Court. Your submission is this.
Yes.
Yes, but you have bit around everywhere unnecessarily.
Now, one thing I like to put, there is a governance model well established, independent government led.
I've heard the learned counsel for the petitioner. This court have duly perused the written statement, wherein a specific preliminary objection had been taken as regards misjoinder and non-joinder of necessary parties. Admittedly, no issue was framed on that aspect in the suit. The record further reveals from the memo of appeal that the said was made a ground of objection in terms with section 105 of the code. And to that effect, the ground of objection is the ground of objection in the memo of appeal is enumerated at serial number 5. This court further takes note of the provisions of Order 41 Rule 2 of the code, which stipulates that the appellant has a right to urge to be heard in support of any of the grounds of objection not set forth in the memo of appeal. Has a right to urge or be heard in support of any of the grounds of objection set forth in the appeal. The power which is available with the First Appellate Court under Order 41, Rule 25 is a power to be exercised by the court on the ground basing upon the grounds of objection so taken or urged during the appeal hearing. The filing of the application under Order 41, Rule 25 was not necessary. Inasmuch as it is for the appellate court to decide as to whether the case ought to have been remanded or whether the appeal ought to have been remanded or the appeal could have been decided by the appellant, by the First Appellate Court. By framing issues and referring them for trial to the court from whose decree appeal have been preferred. However, the learned First Appellate Court, by the impugned order, pre-decided the said ground of objection, even when the appeal was not taken up for hearing. The impugned order, therefore, is not in consonance with the provisions of Order 41, and more particularly, Rule 31. Therefore, the said impugn order is set aside and a direction is passed to the learned first appellate court. Impugn order dated so and so, passed in Miss case number so and so, is set aside, and directing the first appellate court to decide the appeal on its merits, including the ground of objection number 5, which pertains to misjoinder and non-joinder of necessary parties. And in the circumstance, the trial court, the first appellate court can decide the appeal. In a first appellate court is of the opinion that there is a requirement for remanding the suit by framing an issue in that regard, the first appellate court would be at discretion to do so. But the said exercise has to be made only at the time of delivery of judgment. At the time of pronouncing the judgment, in terms with Order 41, Rule 30. This court further observes and directs that the learned first appellate court shall decide the appeal, being title appeal number so and so, without being influenced by its observations made in the impugned order dated 13/12/2023, passed in Mize case number 238/2023. The order of stay dated 6/3/2024 by this court is vacated, and the appellate and petitioner herein is directed to produce a certified copy of the order before the learned first appellate court on 30/4/2024. On that date, the learned first appellate court shall proceed with the said appeal by duly informing the counsel representing the respondents in the said appeal.
Your Lordship, highly obliged.
No more. I have given
And
all
I'm
the
the
reasons.
proper justice.
Proper. Yes, who is appearing? Mr. L.K. Bora, where is he? Yes, your mistake.
I've taken all the steps. Trustee has also reviewed.
Receive. Service? You are appearing for whom?
All the respondents, two answers.
Have you filed the trustee?
Yes.
Okay. This is for not filing written statement, na?
Lord.
Yes.
Lord.
This is an application under Article 227 of the Constitution challenging the order dated
12/9/2020.
Where is that order?
I read
57.
Huh?
Page 57, Lord.
67,
57, Lord.
57. challenging the order dated 12/9/2023, passed in title suit number 318/2023, whereby the learned Court of the Civil Judge, Senior Division number 3, Kamrup Metro at Guwahati, denied the defendants the opportunity had rejected the application of the defendant to accept the written statement on the ground that the said written statement was not filed within the period of 90 days in terms with Order 8, Rule 1. Upon the filing of the instant petition, this court issued notice making it returnable today. This court further directed the petitioner to take steps by way of dusty upon the respondents and file an affidavit of service on or before today. This court have also taken note of the affidavit of service filed on 2nd of April 2024 by the petitioner. Is the petitioner?
It's the number 1.
Wherein it has been duly stated that service was duly effected upon the plaintiffs oblique the respondents herein on 28/3/2024 at 3:15 p.m. On 29, na?
29 signature, return copy, signature put. And 28 copy was delivered.
Okay. That was served, was duly effected, as could be seen from a perusal of paragraph number 3 of the said affidavit of service. Taking into account that the service was duly complete, this court takes up the instant proceedings for disposal at this stage. I've heard Mr. L.K. Bora, the learned counsel, appearing on behalf of the petitioner, and Mr. T.R. Gogoi appearing on behalf of
Respondent number, all the respondents.
all.
1, 2, and 3. 1.
That he responded.
Oh, you
There
are
are
paying
three-
for them?
Lord.
Oh, you are the plaintiff?
Yes.
I thought there was some government is there. Are appearing? Oh, I've heard Mr. So and Mr. Mr. T.R. Gogoi appearing on behalf of all the. Mr. Gogoi, it is because of him this is.
At that moment, he.
Otherwise, I would have, but it is because of his ill health. This is-
At that moment, he had not disclosed that. About
No,
the
understood. You see, but
mere application for
you
seeking
see,
the trial
doing it out here, it's
Uh,
okay.
without the delay condemnation petition. Lord.
Where?
He had not disclosed at that moment, Lord, that he was not well, and mere seeking a application for further time to file a written statement.
Okay. This court have perused the impugned order. The law also laid down and the reasons so assigned does not seem to be in error. However, it is relevant to take note of that there was no fault on the part of the defendants who are the petitioners herein, for which the written statement could not be filed. As would be apparent from the perusal of the materials on record, inasmuch as the counsel who was duly appointed by the defendants did not file the written statement as he was not well. The medical documents have also been enclosed to the instant petition, which also show that the counsel for the defendant was not well, was undergoing serious treatment. Taking into account, it is the opinion of this court that as the fault was not there of the petitioners oblique the defendants in the suit, and it was on account of the ill health of their counsel. One further opportunity can be given to the petitioner herein in the interest of justice. Mr. L.K. Bora, the learned counsel appearing on behalf of the petitioner, submits that the written statement is ready and can be filed on such date as may be fixed by this court. Accordingly, this court permits the defendant oblique the petitioners herein to submit their written statement in title suit number 318/2023 on the next date. This court fixes the next date of the suit on
It fixed,
Huh?
15 May has been fixed in that trial court.
fixes the matter, the trial
16.
court on 22nd of April, on which date the defendants shall file their written statement without fail. Thereupon, the trial court shall proceed with the adjudication of the suit in accordance with law. A certified copy of the instant order be placed before the learned trial court on the next date, that is 22/4/2020.
Marco.
Yes.
As per the order of the Lordship dated 22/3/2024, though we have taken the my lord the statute by the state, and I have already filed the affidavit. Affidavit is not that, my lord. Because
You are appearing?
Yes.
Lordship, I'm okay. This is full response.
Where's your amendment application?
My lord, it is at page number 41, my lord.
Lordship, may I submit one thing? Lord?
Oh, you will submit. I'll give you a
No,
chance.
no, Lordship, no. I am not only married.
No, just one thing I wanted to speak. Where is his application?
My lord, at page number 41 to 50.
41.
41.
What do you want to insert?
My lord, that part is at page number 50, my lord. That really part of the statement.
Is the GMC a party?
Party.
Yeah, party to the suit.
Claim was filed by them, my lord. And only the Guwahati Metro Police Department.
Why are you asking for so many things to be inserted?
My lord, only after the,
What is your suit for?
my suit is for, my lord, I am the defendant, my lord, counsel claim. My prayer is specified, my lord, that schedule D property is approximately 6 lakhs, my lord. That has been encroached upon by the plaintiff, my lord, plaintiff. And to that effect, there is already a commissioner's report, my lord.
Hmm?
Commissioner's report.
Hmm.
I mean, commissioner's report there. And
Who asked for the commissioner?
we ask for the, I mean, the
For what?
counter claim.
For what?
To measure the land of the plaintiff as well as the defendant and to demarcate that scheduled land.
How can the commissioner demarcate without the decision in the trial court?
No, there was a reference, my lord. The trial court has already appointed the main commissioner.
That is okay. But how can the commissioner demarcate?
From the map, my lord, from the cadastral map.
The demarcation power is, how can it be given unless the suit is decided?
My lord, demarcation of the boundaries or the area which is being owned by.
So only to find out what are the boundaries.
Yes, my lord.
Okay. Now what happened there?
My lord, after that he has submitted it report.
Huh.
And my letter friend has already filed an application for cross-examination. That is not yet done.
Then
So, but from the report, my lord, we came to know. And in between, my lord, when it reported, in between, my lord, schedule D property, which was already there in my written statement of counter claim, my lord, that is being occupied by. And they are
no, isn't it your case that they are occupying your descheduled land?
now, my lord.
No, earlier it was not there.
No, earlier
And
it was
why
not
did
there.
you file the counterclaim? there?
Recovery of poison is there.
Recovery of
Then you knew it that you were there.
it was simply, my lord, by way of pillar, I mean the Satya or like that, they had occupied that part.
But there is a occupation. If something happens subsequently, it is already there on report. But your specific allegation is already there that they have trespassed into your land.
Yes.
Then if that be so, why this is necessary? Taking into yes, any subsequent event happens by which anything else is happening, then you need to bring into account. But you are not asking for that demolition in your prayer.
In the prayer, my lord, I have not asked for the.
So if that is not there, not even you are asking for a relief for demolishing of that, you are not seeking for an amendment to that, Why do you require this?
This amendment, my lord. But that part, my lord, is left.
So,
Demolition part
obviously-
is left because of-
Obviously, there's the objection which they have put is wrong. That without the report being accepted, it cannot be, because the report, the moment the report is being submitted, it becomes a part of the record and becomes an evidence.
Right.
But that evidence is only to the effect that they have trespassed and now constructed.
Yes, my lord.
But your pleadings are already there for the construction. For the purpose of they have already entered your land.
Yes.
And
At that
thereafter,
time-
during the proceedings, if they make any construction out there, then obviously it will be, it is already demarcated and found out. Yes, this is the area where they have demarcated. And found out, yes, in this schedule D, they have constructed. Then obviously you can take whatever, what is your relief which have been sought for in your counterclaim? Let's see.
Yes, my lord. That is, my lord, page number 36, my lord.
You already have the relief.
Lot.
Recovery of possession of the schedule
Deep-
deep land by evicting the player, removing and his men, materials, agents, and therefrom. So this is already there.
My lord, unless this part, which is
Why do you need this? This is already, it's a part of evidence which will come in. It is already there.
yes, that is
You
already there, but-
you already have an allegation that he has trespassed into your land. Now it is being further made clear by him that not only that they have trespassed, they are making construction,
that
which
allegation-
happened only during this point of time. Now you cross-examine that witness when comes out. They are only at one point as to when is the time of construction, any knowledge. Matter over. What is this? That is why I wanted to see the amendment application. If whether there was something new. Your case was already there. Because now what will happen is, if we allow the amendment, it goes back, he files again another written statement, issues. What issue? Tell me, what is the issue to be framed? There cannot be any issue.
only regarding construction, my lord.
The construction is already there.
At that time, it was not
Not there, but the construction has happened now.
Yes.
There. It is already there. You need to only ask the commissioner during the cross.
Right.
I give you one liberty out here, subject to withdrawing. That in the circumstance, something comes out when they cross. You will be at liberty to also examine the commission.
Fine.
Good for both. The instant application has been filed under Article 227 of the Constitution, challenging the order dated 21/11/2023, passed in Mize case number 80/2019, arising out of title suit number 266/2012. Whereby the learned trial court, that is the court of the civil judge, Junior Division number 2, Kamrup Metro at Guwahati, had rejected the application seeking amendment of the counterclaim on the ground that the amendment was not necessary for the purpose of effective, the word you determining the real question in controversy between the parties. Mr. A. Satta, the learned counsel appearing on behalf of the petitioner, submitted that the counterclaim which was filed by the petitioner was in respect of the illegal trespass made by the plaintiff over the Schedule D land, and as such had sought for recovery of possession of the Schedule D land, and as such inter alia have sought for in the counterclaim for recovery of Schedule D land, along with removing the men, materials, etc. of the plaintiff. He submits that taking into account the provisions of Order 26, Rule 10, Bracket 2 of the Code, the report of the Commissioner becomes a part of the record. And as such, the petitioner therefore does not further insist on the amendment for which the petitioner would not like to further press the instant proceedings. He, however, submitted that as the case is filed, as the suit is presently at the stage of examination of the commissioner, the petitioner, who is the counterclaim, may be permitted to cross-examine, to examine the commissioner, to re-examine, I think, because his report is there.
He will be accept.
He will cross the,
Will cross.
he will re-examine,
I think.
to re-examine the commissioner in the circumstance. Any thing is necessary for an effective adjudication of the suit of the counter. I've also heard Mr. R.K. Bhuyan, the learned counsel, appearing on behalf of the respondent. Taking into account the above, the instant petition therefore stands closed on withdrawal. The order dated 21/11/2023 therefore stands not interfered with. This court is of the opinion that if during the cross-examination of the commissioner by the plaintiff, the petitioner oblique the counterclaimant wants to re-examine the witness, the commissioner, the trial court shall permit the petitioner to do so. With the above, the instant petition stands. Interim order stands vacated and the parties are therefore directed to appear. The interim order passed on 22/12/2024 therefore stands vacated and the parties are therefore directed to appear before the learned trial court on 29th of April 2024. On that day, the learned trial court shall fix such date for appearance of the commission.
Already a date is fixed. 2/5.
On 2/5/2000.
Like
On 2/5/2024, on which date the trial court shall fix such as per its business, such date for the appearance of the commissioner.
Item 5, for hearing under order 41, rule 2 CPC.
In this council suffering from stress,
Huh?
in this council suffering from stress,
Very well. By the time your people want to do the matter, Many people will die. Anyway, when do you want? At the request of the learned counsel for the petitioner, matter stands to 50 after in the month of May.
Right.
Yes, what is it?
I am for the defendant plaintiff sued for her share over inherited property purchase. Suit was dismissed, then first appellate court reversed the judgment. It was not met, but ABN sued her share was there. Except
ABNC.
ABNB was there and C schedule was not. And I am for the defendant. I am for the brother and plaintiff is sister.
You are a brother.
Our case is that she was already given her share and she already took her share. That is the
That is a question, that's a finding of fact.
Sure.
How is it becomes a question of law?
and not the property.
Whether the findings arrived at by both the courts are correct when there is no endeavor by the plaintiff to prove Exhibit 1.
Lordship, wrongly died for. Then after that,
It's a family tree. Family tree.
Who is the Gautam Bora?
Gotapara brother, father is Punaprabha Bora and
That's
Dimai Bora.
The heirs of Pranav Bora.
Bora died.
The heirs of Surendra Bora. Surendra Bora.
There is of Surendra Bora.
Surendra Bora.
Who has got it?
The
Gautam Bora is
the defendant, the appellant hearing
and Amoni Bora is Amon Bora is
is the plaintiff.
how many plaintiffs were there?
All one plaintiff, other sisters have supported the case of the plaintiff.
Plaintiff.
And mother is a lady living with the son. He's not mentally sound. As per
Who
the
is not mentally?
mother, as per the version of the
So the son wants to take everything
yes, yes,
and deprive all the sisters.
Yes.
Right? It said on that.
But the share was given to third party.
It will
is
say-
It's a question of fact.
it is
Let's see whether the first appellate court did not part the
not the issue of a
maybe. What is this clean hand business? In a suit, what is this clean hand business?
He has not stated all the properties of father. He has included some of the properties of father.
You brought it.
Lordship, her daughter is also evident in.
Now, understood. You also brought many properties. Did you bring the other property?
No, Lordship, there is no counterclaim. And Lordship, the trial court already.
Over
discussed
the
the
ancestral, it is all sustainable in presence of the admission of that he has already received a share of land measuring 1 kata 10 lechas.
Schedule C. This is Schedule C. The father has, in the lifetime is given to the daughter. They have stated in the evidence, and in the lifetime your soul. Schedule C. Part of
In
one-
excess
one-
of her share.
No. At the lifetime, the father has mutated in the name of the
Gifted.
father, the Surendra Bora, has mutated in the name of the plaintiff in his lifetime when he was alive in 2008, and he died in 2009. At the lifetime,
How did the gift happen?
he has mutated as per the evidence of the
How is it possible? Are these Muslim?
no.
Well-
But the
Mohammedan law does not allow if a land has to be gifted, it has to be gifted by a registered document.
it is a person of the defendant in the evidence.
They are saying
They are saying.
this
He
therefore
also
comes.
admitted.
And
She
it-
had already received the share. How is the share she has received?
He has already admitted, Lordship. In the trial court judgment, your Lordship will find page 34,
Hmm.
34, 35, Lordship, there is the
Now, what does the
Number
first
three.
appellate court say?
accepted court, Lordship court on its own divided the land mentioned in the Jamabat text.
Hmm.
And thereof share was given to the state. Whereas the
In view of the above, this court is of opinion the plaintiff has failed to establish her claims by quote and evidence so as to entitle her to a decree as paid. Hence, the plaintiff is not entitled to declaration of her right title in the partition of her remand. This is a trial court judgment.
thereof, page
Where is the
30
first appellate court judgment?
Finding is page 65, para
Hmm?
34. Para
Page
page
65.
65.
65.
Sorry, page 62, para 29.
Okay. Regarding the, I find that the argument of the limited to the what is exhibit 1? Jamamundi.
Yes.
Her name is there.
article is there, but also in excess per share.
How?
In the schedule, he already was there was a
You claim Schedule C. Why didn't you file the counterclaim? Now tell me, how is it possible somebody being gifted unless there is a registered gift during the lifetime? Mutation is not the somebody's name is being inserted. How do you this court take or any court can take judicial notice of that? If she's claiming Schedule C, is she not asking for partition of Schedule C also?
Yes, we are
Please
giving
asking
schedule C,
for-
but the court has, appellate court has given schedule A, B, and D, not C.
What is C? C is
C
who?
is the land
What is how does the appellate court take note of Schedule C? In Schedule C, the quantum of land is 2 biga 1 kata. However, the defendant is the contended out of the total land mentioned in Schedule C, half of the same, that is 1 biga, is under the possession of performance defendant, and the remaining half is under the possession of the predecessor of the plaintiff and the defendant,
Is-
which the plaintiff and
Where
the
34?
defendant inherited. Thus, it is seen the defendant admitted that only half the land is inherited by the plaintiff as well as
Para 34 is given.
That is what I am reading. Usual purpose. Let's see what is the preliminary decree part.
Not that you get all other schedules, but the share of Antuk is also there. It's not attached to one.
Not have any share. So here it says that the plaintiff does not have any share in Schedule C land.
That was not given her. As that is the first state court said that he has already received, but not.
But when the decree is seen or the order is being passed, it categorically says that the plaintiff does not have any share in Schedule C land.
Yes.
So in while carrying out the partition by the authority has to therefore look into it that Schedule C, the plaintiff does not get anything.
He was not given. Only A, B, and C was given by the first state. Which was dismissed by the trial court, but first state was modified and on A, B, and C was given afterward. 1/5 share, and it's admitted that their Antuk share is also there over the.
So what is tell me, is any the land which belonged to your father,
and my father's brother,
whatever may be, all this land, whatever have happened, was there any transfer in your name or their name by way of any registered instrument during the lifetime of Surendra? So, what is there to interfere? A simple case. It should have been, in fact, a final decree. Whether there are houses out there.
Yes. In Schedule D, the defendant number, the son is presiding. Schedule D. And he is also admitted in the cross examination also in the WS in para number 11 and then 15 they have admitted. They have admitted this is the property of Shannon Bro.
Para 35.
Para number 11 of the WS. And in the cross, he admitted.
No, in fact, if there is any house out there, they will look into it. It is for them. It is during the partition proceedings, the trial court, the collector or the revenue people will look into it. Just for example, if one land is in Pennsylvania, the other land is in Gorsuk. Then if a person is there in Pennsylvania, his land's value will be more. Then what they have to do is then they have to calculate the OLT. So this will be done by them. What is there? There is nothing wrong. No, these are all findings of facts, whatever it is. No, unless you say, yes, this particular land was given to me on the basis of at the time there was a mutual agreement, whatever may be, at that point the oral agreement, and thereupon I got this land and the other, and the finding of fact has not been taken into account to that effect, then it is a case of perversity at best. Otherwise, it is nothing.
That was our case, but it was already given her share by the father. That is admitted by the plaintiff also. It trial court the share is rejected. Page 34 proceeds the plaintiff.
How can a share be given to her? Tell me. No. Madam, kindly appreciate one thing. A family property, these are all Dayavaga. How can you give somebody during your lifetime? It only happens when any right is conferred upon them. The right will be conferred upon them only when this person is dead who owns the property. Then a right is conferred amongst them and these people then jointly may do so. If any property has been given during the lifetime of that person concerned, then there is no, is it your any case that after the death of so-and-so anything happened? There, no case.
are there only that
Madam, madam,
there are 30.
I give you a very good suggestion. I am not sitting on 8, 18, 19, 20. You get these matters listed anywhere in these dates, you may get an admission. Else it's a case of dismissal. Which one? Which date do you? At the request of Ms. R. Chaudhary, the Learned Counsel, matters stands adjourned to be listed again on 19th of April.
19th, there's the election in Dibrugarh. I have to go for voting.
On 8th of April. 8th. You will get an admission. No. Yes, what is this? Wakalat number file. I had some kept on.
I'm for respondent number 2345.
Okay, everybody appearing. What is the matter about?
Well, the application for order 18 rule 17 for cross-examination of PW 1, 2, and 3 and for filing additional evidence defendant that was rejected.
Additional evidence on the order 18 rule 17A.
70 days. They have filed two applications, my lord, under 151 as well as under order 18 rule 7. That those were rejected.
One for recalling a witness.
Recalling of it.
Why was it rejected?
It was rejected because, my lord, they had taken up to number of times to cross-examine, my lord, the official witness. Although they had filed Hazira, my lord, but
Let's see the order.
order, my lord. Order is at, my lord, page number 49.
Yes, Mr. Counsel.
My lord,
We dispose of
my
this
lord,
matter.
My lord,
petition, the petition, first petition was filed in the year
It's okay.
for vacating 3 orders, my lord. These 3 orders were passed for closing the cross-examination of DW. And subsequently, the DW came, date for DW was fixed. The earlier engaged counsel, it did not take any effective step. That I written in the petition itself. Because of that, even DW was. Thereafter, we were engaged in the case. So we had to go through the record. While going through the record, we discovered that the earlier counsel who have been representing the litigant in the case, it did not take any effective step. That being the situation, my
Who is
lord,
that
what
counsel?
we did, first we
Who is that counsel?
counsel and moreover, unfortunate,
Who is that
Coun-
counsel?
counsel who represented it, he was already passed away.
my lord, the earlier counsel, those were not changed. They came in addition with the earlier counsel. That is reflected in page number 18.
Okay. Now, where are the orders by which it has proceeded ex parte?
Impugn order, my lord, page 14.
Huh?
Impugn order, page 49.
That's a long order.
Whereby our 2 petitions
Two
were
pages.
rejected.
49.
49.
No, where is the first order by which it was closed?
My lord, first order was passed.
Record is it?
Yes, yes.
Ah.
My lord, first order was passed on 1/9/2014, and thereafter,
These type of matters has to be disposed of, giving them the liberty, whatever may be,
yes, my
whatever.
lord, and immediately steps were taken.
My lord,
The
since
pendency took place in the High Court, Your Honor. So, my lord,
Yeah.
because
Where is this? This must
37
be in Guwahati, na, somewhere.
Guwahati,
Writing seems similar.
37 2014.
30?
7 2014. 30.
Both sides are represented equally. Who filed the application for mediation?
Mediation we filed. Once we entered the appearance, then immediately we thought that yes, mediation, because ATR was not resorted to earlier. So we wanted to explore that. So immediately one petition was filed for mediation. And utmost effort was put for, settle the issue in the mediation. But somehow it failed. And thereafter immediately these petitions were filed. And we have elaborately stated in the petition itself that yes, the purpose and the necessity under which these petitions were filed. The wife of the litigant was suffering from many ailments. She also passed away, wife of the litigant.
What is the property?
Collect the money suit for
Money
recovery
suit.
of 5 lakh.
Huh?
Money suit for recovery of an amount of 5 lakh 7.
So
They entered
my
into an
lord,
agreement with us.
one plot was owned by my client. That plot was agreed to be purchased by the other side, plaintiff side. Then they started making payment in small installments. And ultimately they said that no, we are not purchasing the property. So ultimately they want to revoke the agreement. And accordingly it was revoked. 2 checks were given to
Those bound.
check were given to the other side. And those 2 checks were bound. And thereafter criminal case was filed against my client.
What was the value of the checks?
45,000 and 45.
45,000, 45,000. Just 45,000, 45,000.
45.
45, 40.
My lord, and thereafter what
I'll
happened?
restore first.
And thereafter,
No,
my
kindly listen.
yes.
I'll restore first deposit 90,000.
My lord, what happened?
There's
We
nothing.
have only made payment, my lord.
Of
Because of that only the criminal case has been withdrawn.
they made the payment.
Yes, we cleared the deal.
That,
And
Huh?
thereafter they
That I
filed
have
this civil suit,
Huh?
this money suit.
After payment, you
Yes,
filed
after
the suit.
making payment, after paying the entire due, they filed this money suit, my lord.
well, out of total
This is
sales
a
consideration
matter
of,
of merit, otherwise.
out of total sale consideration of rupees 5 lakh 60,000, my lord, we had paid an amount of rupees 5 lakh 7,000. So after that, they again insisted on payment of another 1 lakh as additional amount, my lord, which we refused because, my lord, I was in widow, so I did not have that much of amount. So they said, my lord, there was a village, my lord, merely in between the localities, my lord. It was decided that my lord, he'll return back the money of 5 lakh 7,000.
Mr. Counsel, you want the reversal? 50,000 is the cost. Nothing more. 50,000 is the cost.
These are all merits of the case.
I am not on merits of the case. You have not done, you have not, I would have understood. You did not know anything. You went for arguments. Many times you have sought for arguments. And thereafter, when the matter came up for, again for argument, then you said, let us explore mediation. After the mediation failed, then also you took 2 adjournments. And then you filed this 151.
Lordship, you kindly permit me to submit my case. Thing is that it was, my client was represented by a different lawyer.
Understood, but I am saying from when you appeared.
Yes, immediately.
No,
there was-
you did not file. That is why I asked, who went for mediation? Who advised for mediation? Why? Because you see, kindly see here.
in the
No, kindly see.
Yes.
18/12/2014, it was fixed for arguments.
Yes.
On 27/1/2015.
Yes.
Okay. Then 7/3/2015, 7/4/2015, you appeared
Yes. I entered appearance
on
7/4/15.
on 7/4/15.
Yes.
Then it's a newly engaged counsel, 7/4/2015. Then
Yes.
you say, as a last chance, you wanted an time. Then you file a petition, let it be go for mediation. Next
Mediation.
day.
We wanted a settlement.
No,
We
it's
wanted
okay.
a settlement.
Then on 25/6, mediation, 31/7, mediation.
Yes.
Then again you sought for arguments and you did not argue. Then also you didn't. Then you at the end you file an application under 151.
No, I did
This
not-
is absolutely a case. It's an afterthought. You want an
my lord,
opportunity,
immediately thereafter.
Mr. Counsel, you want an opportunity, you have to pay. Otherwise, no. I'm not going to undo a thing because you see, they have spent a lot of time on this.
Yes,
They
it's a
just
money
stay.
suit, I understand. And in our petition
And
itself,
what about the cost? The proceedings have been stayed out here unnecessarily.
my lord, we
Is
have
there
already
stay?
stated
Stays
in our
there, my lord.
petition.
Okay, let the
2016,
record go. I'm not going to decide this. I'll fix it for hearing and let it come after 10 years and then let the suit be disposed. Return direct. I'm not going to do that. You have to pay cost. If you don't pay cost, I'm not going to do it. Tell me, are you willing or no?
Accepted unless I have instruction from my client, I am unable to
Chalo.
make submission.
Your instruction, you don't require instruction for dismissal. This is an application.
So if I kindly see the amendments made in the petition, where
Whatever
is
may
not
be.
a time frame that for disposal
I
of the petition.
am not going to touch anything. This is not the manner. I would have understood the next day you come. You don't go for mediation and all these things. It's a ploy and a delay on your part.
There is lapse on the part of the earlier lawyer.
The lapse of the part of the lawyer, let us examine, assume it, that yes, there was. What were we doing from 7/4/2015 when you appeared?
And thereafter, it was
Then,
not listed, my lord.
Don't make all this submission.
It was not listed. And because of that delay,
Not listed. 7/4/2015 was before the trial court. You said that, okay, give me a last chance to argue. Then the matter comes up.
No, it has been stayed by this honorable court, my lord. The stay order is there.
Okay. This is an application under Article 227 of the Constitution, challenging the order dated 28/2016, passed in petition number 3910/2015 and 1973/2016 by the Court of the Learned Civil Judge number 3, Kamrup Metro at Guwahati in Manisut number 316/2011. Pustak. From a perusal of the materials on record, it revealed that the respondent herein, as plaintiff, had filed a suit seeking realization of an amount of rupees 5,34,550 along with interest. The said suit was registered and numbered as title suit number 316/2010-11. Itu 507,550. Isn't it? 507. I have filed the suit seeking realized recovery of rupees 507,550 with 9% interest per annum from 4/5/2009 till institution of the suit, along with a sum of rupees 27,000 towards the cost of building of the construction materials and pendant like and future interest at a rate of 9% from the date of institution of the suit. The said suit was registered and numbered as title suit number 316/2011. The petitioner herein, who was the defendant, filed his written statement. On the basis thereof, as many as 6 issues were framed. From a material, it further transpires that on 28/5/2000, on 5/3/2014, evidence on affidavit of PW1 was filed. Thereupon, on 28/5/2014, the defendant and the plaintiff sought for adducing the evidence of the office bearers of KU Committee which was allowed in presence of the defendant. On 30/7/2014, the official witnesses and the plaintiff witness was duly present. However, none appeared for the defendant till 3 p.m. However, for the ends of justice, the court fixed 1/9/2014 for evidence of the official witness. On 1/9/2014, the plaintiff witness as well as the official witnesses were duly present, and for the defendant, that is the petitioner hearing, Hazira was filed, but there was no one from the defendant till 4:30 p.m. for cross-examination of the plaintiff witnesses. Under such circumstances, the court by order dated 1/9/2014 held that the cross-examination of the PW3 could be deemed to have been declined, and the PW3 was discharged, thereby fixing 24/9/2014 for cross-examination of the PW1 and 2. On 29/4/2014, both the plaintiff witnesses were again present for cross-examination, but the defendant was not present without step. But the defendant was absent, and that too, no steps were also taken. Under such circumstances, the cross-examination of the PWs were deemed to be declined by the defendant, for which the case was fixed on 18/12/2014 for evidence of the defendants. On 18/12/2014, none appeared on behalf of on 18/12/2014, though both sides appeared, but the defendant did not file any evidence and also did not file any petition, for which the suit was fixed for 27/1/2015 for arguments. The record further reveals that on 7/3/2015, again both sides were present, and the counsel for the defendant filed a petition for another date for argument, and the trial court permitted the same, thereby fixing 7/4/2015 for argument as a last chance. On 7/4/2015, a new set of counsels appeared on behalf of the defendant, requiring time instead of carrying out the argument. An application was filed by the defendant to the effect that the matter be referred to mediation. The court, taking into account the above, fixed 25/6, referred the matter to mediation, fixing 25/6/2015 for report of the mediation center. However, no report was submitted on 25/6/2015, for which the matter was again fixed on 31/7/2015. On 31/7/2015, the report was submitted when the plaintiff was duly present. However, the defendant was absent, for which the trial court again fixed on 11/8/2015 for arguments. It is under such circumstances that on 11/8/2015, that too at 12:30 p.m., the defendant filed an application under section 151 for recalling of the order of 151, and which was numbered as petition number 3910 of 2015. The plaintiff side filed objection on 9/9/2015. While the said application under 151 was pending, on 15/6/2016, the defendant filed another petition, being petition number 1973 of 2016, for recalling the witnesses for examination and for allowing the defendant to lead evidence. The said petition was numbered as petition number 1973 of 2016. By the impugned order dated 28/2016, the learned trial court rejected both the applications, with there being petition number 3910 of 2015, as well as the petition number 1973 of 2016. The learned trial court, by the order dated, impugned order dated 28/2016, rejected both the petitions. Holding inter alia that no materials was placed on record on the basis of which to substantiate on the business, to substantiate the grounds and reasons the ground on which both the applications were filed. It was also observed by the learned trial court that the ground shown did not inspire confidence, because there is no reason to believe that the defendant was suffering from such ailment which prevented him from appearing before the court. Where is his petition under order for the year and 19?
My lord, at page
I've heard the learned counsel appearing on behalf of the petitioner as well as the respondent.
234.
I am looking for respondent one,
Who are you?
state of Assam,
Huh.
justice. Law and justice.
Law and justice will take when the truth is speaking. Put him behind bars. Where is that application?
My lord, under order 18, my lord, page
No,
43,
because-
my lord, 43 onward.
151 is at page 18.
when was it filed?
151 11 8 2015.
Eleven.
8 2015.
Page 18.
You filed a review also.
Did not file review, my lord. Filed subsequent petition. The subsequent petition was filed under order 18-7. My lord, and so far submission of material is concerned, submitted the material before the trial court. That has not been affected. In the
Yes. Are you paying 50,000 or not?
50,000 is too high, my lord. Lordship may kindly consider
No consideration.
the total amount involved, and he has already paid a hefty amount for the, I mean, this petitioner.
Mr. Counsel,
Yes, my
what
lord.
you are submitting,
Yes.
when the counsel made the mistake, you filed this application after a new counsel has entered, after 7-4. In your first application under 151, you did not blame the counsel. You
Subsequent, we
blamed
elaborate
the,
this.
listen, you did not blame the counsel.
Yes.
In the second petition under order 18 rule 17, you are blaming the counsel. Yes.
Yes,
Kindly
yes, very
see.
correct,
Then,
very correct. My lord, this is
then-
all up to your lordship.
then
Right.
you can't
It
make
is-
this like this. One, he is not there after a few dates goes, then you have the habit of blaming counsel.
That's very much there, but the fact is that he did
Why-
not take any
Why?
step.
Then why it is not there in the 151 application?
My lord,
Kindly see 151, kindly read. Moreover, the defendant in this context begged to state that he and his wife have been married for several years without an issue due to the infertility problem, As such, they were undergoing continuous treatment in various places like medical institution, clinics, so and so, for several years, compromising with their duties and obligations only for the sake of having an issue in their lives. Moreover, the wife of the defendant is a cardiac patient requiring constant medical follow-up from time to time, in consequence whereof the defendant, due to the above problem, has been unable to take steps by himself or instruct his engaged counsel to take steps in case of on his behalf. As such, the court passed. This
Yes,
is your.
Very correct. Very
No, you are making a false statement. You made a false statement also, Mr. Counsel. Why did you make? It is not the stand of the defendant in the first petition.
I thought the counsel, earlier counsel with the junior counsel, he did not understand anything. Because of his fault,
Mr. Counsel,
because of his fault, he did not take any
whose
step.
name is this?
So ultimately,
Ranjan Sharma, whose name?
my name is
Then
Ranjan Sharma.
you filed that application under on 151.
Yes, yes. very
You
much.
categorically stated that your client did not instruct his lawyer. This is the petition. In the second petition, now you blame the lawyer.
I don't- because
We impose another. Okay, don't worry.
Ah.
50,000 for your client, another 50,000 for you.
Hello.
Which one? Mr. Counsel,
The minimum
I-
cost may be imposed
No,
and it can be.
I'm going to dismiss. You want, I'm imposing 50,000 cost, I'll give it to you. Else, I'm not going to do, because your conduct of your counsel is too bad. Of you. You are the person who drafted this petition. You first on the first, and you see, you are all brothers of the same fraternity. How can you keep on blaming all your counsels? Every time I see that there is a blaming on the counsel, you have to stop that. I can only do it if you pay 50,000, else nothing do it. And if you say anything more, I can make it 75.
And it-
No consideration. And 5,000 for you.
my lord,
Your
cheating is-
5,000 will go to the legal services
my lord,
authority.
my lord, cheating, so far cheating is concerned.
10,000.
Very much there, but unless the evidence are brought,
But this court have perused. Because this court have also heard Mr. R. Sharma, the learned counsel, appearing on behalf of the petition, whose specific submission was that the earlier counsel who was engaged in the matter did not take proper steps which had resulted in the state of affairs for which, in the state of affairs, which had resulted in passing of these orders. And as such, on account of the fault of the earlier counsel, the petitioners who are the defendants in the suit should not be penalized. I've also heard Mr. A. Iqbal, the learned counsel, appearing on behalf of the respondent. This court had perused the petition under section 151, which was registered as petition number 3910. This court in the previous segments of the instant order had categorically mentioned under what circumstances and when the said petition was filed. In paragraph number 2 of the said petition, the ground which had been taken is that the defendant failed to instruct his counsel. On the other hand, in the petition under order 18 rule 70, which was the petition bearing number 1973, it appears that the defendant took the stand that the earlier counsel did not inform the defendant Therefore, both the stands are contradictory on the face of it. In view of that, it is the opinion of this court that the conduct of the defendant, who is the petitioner herein, does not inspire this court to interfere with the order, impugned order dated 23/2016,
My lord, 28/2006.
16. And accordingly, the instant petition stands dismissed because the registry is directed to immediately remit the file, the trial court records to the court below. This court fixes the matter as both the parties are appearing. This court fixes the matter on 14th of May before the trial court, and court to nam to deliver.
Civil just number 3 come.
And both the parties to appear on 20th. The registry shall ensure that the records of the suit are received by the said court on or at least 5 days before the next date so fixed by this court. And for that purpose, if necessary, the registry may resort to a special measure. Interim orders depending stands vacated.
Deeply of it.
Yes, what is this?
My lord, that today that matter fixed for my lord the service of notice of the respond number 2 man. I am repeating respond number 1 man. Office notice there.
Who is respond number 2?
2 is one of the connected party. Against which my lord they have taken a step, but thereafter my lord the direction was given by this honorable to take step to his
Corrected.
Sincerely address. I think they have taken
Yes, we have
step.
taken steps.
Huh?
We have taken steps on the correct address also, but
Is there a stay?
Stay there.
Has the award been
yes, sir.
awarded in whose favor?
Award is in my favor, my lord, which they have put on the step.
The arbitration proceedings went in your favor.
Yes.
Means who was the claimant?
I am the claimant.
So you have
This is the
you have
four-
put it for execution.
Yes, ma'am. This is the 4th round of litigation.
Understood. Have you put it for execution?
No.
Why?
My lord, I think there is stay.
Yes, there is a stay of it.
We vacate the stay. Or you argue the matter. This is 37 appeal has to be constricted under
Well.
27, 34. This is not done. How can an award be stayed like this? What is wrong?
My
What
lord,
is
the
the illegality?
impugned order contained in page 31.
What is the illegality, madam? Why is respond number 2 required?
It's not required, ma'am. His role is not.
Oh, respond number 2 is a performer respondent is the arbitrator.
Yes.
We struck it off. Taking into account that the respondent number 2 is an arbitrator whose mandate expires with the termination of the arbitration proceedings. The presence of the respondent number 2 is not required. Mr. S. Samaria, the learned counsel, appearing on behalf of the respondent, submit that there is an existing award in the favor of the respondent, and in view of the stay order passed, the award, he is not in a position to put into execution the said award. He therefore submits that the matter requires to be heard on an urgent basis. List the matter again on 9.
Right.
11 on 23rd. 23rd of April at 2 p.m. for finance.
Apply.
Please, Your Lord.
The LCR of the record reveals that the LCR of TA 20/2016 have not yet been received. The registry shall ensure that the said that shall take effective steps for receipt of the type LCR of TA 20/2016. Immediately upon receipt thereof, the matter be listed for hearing.
20 and 21 TL. 2 years, 20 and 21.
Okay.
21.
One will be in 20, will be in item number 9.
Item number 9 and 10.
9 and 10.
10 together.
How many TAs required?
Two years. Both are it.
Okay. One is 20 and 21. 20/2016 and 28/21
21 of 2016.
Both.
Both
are required.
are required.
Sure.
Moreover, let's say on 22/3/2023, this honorable court directed the appellant to provide extra copy of the document, but they have not provided till now.
Oh, Division one bhai.
Order dated 22/3.
We should dismiss the appeal on this
Appellant
ground.
cannot
Why
provide
should
the
we are not serving copies, we dismiss the appeal? No,
No,
he has not received.
okay.
He has not given.
Just shows my signature.
Has he given?
No, no, no.
No,
I have
then
not
we
signed
should
it.
dismiss the, no, non-service is a good ground for
22/3/2023.
dismissing it.
22/3/2023, this honorable court appellant shall have a copy of the petition to the respondent. To both the RS both 47 and
There is a CRP also.
yes, 30 also. Lord.
Why, what is this CRP for?
Today, there was two issues are involved. One is for ejection method and one is for determination of the leave.
Hey, wait. No, I have not given. No, why? I don't understand. Why is the RSA?
Yes, no, there is a counterclaim regarding the other part, regarding the lease part.
No,
Okay.
first RSA is admitted.
Admitted.
And what is the other one?
The
CRP?
one is against my ejection form. There is two schedule premises, schedule 1 and schedule 1 regards to I was a tenant there, so I was evicted by the work person. Against that, I filed a civil request. And I had a counterclaim regarding the schedule 2 premise. Both the issues were decided by with a single judge. Accordingly, I filed two appeals, two tackle appeals. One is against the ejection, another is against the termination of the lease. So, both the appeals were also dismissed. That is why I filed one second appeal here for this
In the
and division against that.
And you have not given copy.
The copies were served to notice, all copies were sent to notice. Anyway, I will today only will I provide.
So, yeah. Okay, service is not complete, madam.
Whether it is not a bit, my lord, respondent number 7, my lord, for the date it is that his name was Alumia. But the petition it was typed as Alumia. So I feel allowed to amend the name and directed to take this again, my lord.
Why should I
Because
give
of
you?
that, my lord,
You file, why should I allow you now? Because taking into account that the service is not complete, is the matter of the completion of service.
Yes.
I'm appearing for respondent number 30 on behalf of the assemblies.
Give your name,
I'm preparing for the state.
Yes, my lord.
give your name. You have not taken steps on respond number 1 to 4.
The one is appearing, right? I'm active responsible. Pro forma, while the names may be struck off.
Mr. Jed Mukhi, the learned counsel appearing on behalf of the appellant submits that the name of the performer defendant respondent number 1 to 5 may be struck off, taking into account that neither they participated in the trial nor in the first appeal stage. Mr. Swarenso appears on behalf of the
Respondent number one.
respondent. So, taking into account the above, the service of the names of the performer respondent, performer respondent numbers 1 to 5 is struck off. The LCR having been received, lists the matter for hearing in its usual court. The petitioner, the appellant is further directed to, the counsel for the appellant is further directed to file a fresh memo, amended memo party in view of the instant order before the registry by 9/4/2024. In view, and the registry shall appropriately correct the cause title and update the same in the CIS. You file it 9/4. Otherwise, what will happen, their names will continue. And then later on, when the matter is in your favor, you go to Supreme Court and they will say these people were not.
Right.
Yes. Service complete. LCR. Hearing complete. Service complete. LCR having been received, lists the matter for hearing in its usual courts. LCR received.
All right.
Mr. Counsel, I don't think he also here. I am further here. Speak aloud. He is also not hearing. Tell me, what do I do? Should I come down?
Service report has been received from one.
I hope the learned counsel appearing on behalf of the appellant submit that in view of the office note dated 11/12/2023, the appellant would take appropriate steps to list the matter after 3 months. You know why 3 months has been given? Why? Because of the office note says respond number 13 expired. That is why 3 months. I hope you will do it. Okay. उसी में करना है तो. Steps.
await service, one, await service. Or order dated,
Registered post, not mistake.
is
Why? Is there an order to that effect? Take steps. Response number 4 had expired. Or expired. What have you done?
it was date,
Hmm?
date of date.
You don't know. So what to do? You made Hiralal Chakraborty. He's a deed right. And as such, the right to sue, does it survive upon him after his death? So we have to strike off. Ms. Coenso, the learned counsel appearing on behalf of the appellant, submits that the respondent number 4, who had expired, as could be seen from the office note dated 14/3/2023, is he was the deed writer, and as such, as the respondent number 4 was arrayed as a defendant in the suit, in the capacity of a deed writer, the right to sue against the legal representative therefore does not survive. The learned counsel further submitted that in that view of the matter, this court may proceed with the instant appeal by striking out the name of the respondent number 4. Taking into account the above, the name of the respondent number 4 is struck off. It further appears from the records that the appellant have not taken steps by registered post. The service, further to that, in the office note dated 25/4/2023, it revealed that as regards the respondent number 1, 2, and 16, the service report had not been received. The appellant is directed to take fresh steps upon the respondent number 1, 2, and 16 by registered post as well as by usual process by 9th of April 2024. Same order is still there. IA has been disposed of as well. Okay. I agree. This is an application under Order 39, Rule 1 and 2, read with Section 151 for grant of an injunction restraining the opposite party oblique the plaintiffs from alienation of the suit land and or otherwise disturbing the possession of the petitioner oblique the appellant over the suit land till the disposal of the appeal. The accompanying appeal has already been admitted by formulating a substantial question of law by an order dated 26/8/2022. This court have also taken notice of the order dated 26/8/2022 passed in the instant application where both the parties were directed to maintain status quo in respect to the suit land. Taking into account that no objections have been filed and appeal have already been admitted, this court is of the opinion that the status quo so directed by this court on 26/8/2022 be continued till the disposal of the instant appeal. Accordingly, the status quo order in respect to possession and alienation be maintained till the disposal of the instance of the accompanying appeal. I extend this court. State.
If point number 2 expire, and they may be start off because
Who expired?
number 2.
Ah.
And they may be start off.
Kako.
Legal errors are already on record.
What about the respondent number 5?
5 lordship, as per office note dated 12/6/2023, is in third, by brother. As per office
Okay,
note,
then service is complete.
complete.
What is this for? IA for?
IA for condonation of delay.
Taking into account, this is an application file for condoning the delay of 22 days in preparing the accompanying second appeal against the judgment and decree dated 4/2/2022 passed by the Court of the Civil Judge number 1, Kachar, in title appeal number 19/2018. First, this court have duly taken note of the grounds assigned in the said application. And in the opinion of this court, the same constitutes a sufficient cause within the meaning of Section 5 of the Limitation Act 1963. Accordingly, the said delay of 22 days in preferring the accompanying second appeal stands condoned. In the interlocutory application stands disposed. The registry is directed to register the accompanying second appeal and list the matter at the stage of Order 41, Rule 11. I stands disposed.
15.
That, if I have put the 12,
What?
I have put a notice for 12. But should I start not reporting?
Setting aside abatement.
But
Hmm?
yes, sir. They are not reporting it that
File it by way of an affidavit.
Fine.
When did you inform and whether it has been received along with
they
your
have
post?
protected me. Thereafter, they have protected me, but they have not come up.
They have received it.
They have,
Put it by way of an affidavit.
Fine.
Mr. Adhod, the learned counsel appearing on behalf of the applicant, submits that a notice of withdrawal have already been issued to the applicants on 29/2023, which have been duly received by the applicants on 25/9/2023. Thereupon, the applicants, though have contacted him, but no further steps have been taken. This aspect of the matter, in the opinion of this court, requires to be put by way of an affidavit so that appropriate orders can be passed. List the matter again on 3rd of May 2024. In the meantime, the said application, the affidavit be brought on record.
after. Can I take it out?
Right.
15.
Whoever appears for response number 2, huh? Your brother, why are you not appearing for them? Both of you must have been together, defendants, filed a joint written statement. Then, why you are not appearing?
To appear only for defendant respondent number 1, Your Lordship.
Why not the other? Both are same defendant.
I may obtain instruction, Lordship.
You obtain, no, you appear. Or if you don't appear, this can't go on. Both are brothers filed together, everywhere you have been together. And now when it is the question of appearing, one does not appear. Isn't it? Mr. H. Puragwai submits that he it is seen from the records that the respondent numbers 1 and 2 are both brothers. The said respondents were defendants in the suit and submitted a joint written
We
statement.
were the plaintiff. We were the plaintiff.
Huh?
We were the plaintiff.
Who?
Our suit was dismissed, Your Lordship. Thereafter, we have filed the title appeal. Again, title appeal was allowed, and against them, the defendants are here. In the original suit, we were the plaintiff.
No. See the second appeal. Who is Dipali Bora?
He was the defendant in the original suit.
And these were the plaintiff.
Lord, they were the plaintiff.
Yes. Why have you made this mistake?
Because
Typographical mistake.
What is this typographical mistake? Hello? It is seen from the records that the respondent number 1 and 2 were both plaintiffs in title suit number 04/2013. They proceeded with the said suit together being jointly represented by a same counsel in the trial court as well as also in the first appellate court. Mr. 8 Puraguay appears on behalf of the respondent number 1. The respondent number 2, the office note reveals that neither AD card nor unserved notice has been received from the respondent number 2. But taking into account that both the respondent number 1 and 2 are joint plaintiffs and they have all along participated in the said proceedings, this court deems the service upon the respondent number 1 and 2 complete. LCR is received. Taking into account that the LCR has been duly received, list the matter for hearing in its usual course. All represented.
Record.
Service being complete, records being received, list the matter for hearing in its usual course.
Public.
20.
Yes. Records. Records not called for. Pursuant to the order dated 19/7/2023, by which the instant appeal was admitted and notice was issued to the respondent, the respondents are duly represented. However, it is seen that the records, the LCR, have not been called for. For the purpose of proper adjudication of the instant appeal, the LCR would be required. Under such circumstances, this court directs the registry to call for the LCR and list the matter for hearing immediately upon receipt of the LCR. Service complete, LCR received, list the matter for hearing in its usual course. 20 21 or 2 लिखिबो. Service is complete. LCR has been received. List the matter for hearing in its usual.
May I please, Lord? I'm appearing for respondent number 2.
What is this scan copy of the LCR has come? Why?
Lord, actually the petitioner problem they are not appearing today. I'm respondent number 2, private respondent.
Why the
there is
petitioner
a
is not there?
baseless revision actually.
What is
Against
this
my
call
impleadment
copy?
order, they have come for revision again.
Huh?
Against my impleadment order,
I was impleaded in a particular money suit. Against that order, they have come for revision. Thereafter, they made the appeal also, first appeal. And the appellate court also appealed this particular order. Thereafter, they come against these two orders. No illegality is there, no illegality is there, no nothing error is there.
Show me that order.
Order may kindly be seen, Lordship, in the last portion. They have not numbered in the entire petition.
Huh?
They have not numbered in the entire petition. Lordship, impleadment order is page.
In our copy.
In our copy, no numbering is there.
Very well.
And
Let me
9
see where is my
2023
number.
order may kindly be seen. Landed Munship Code number 3. Junior Division number 3 order.
An
Guwahati.
application paid by 5 revision petitioners under 115 against the case number 5455 order. Order dated
9/3/2023, Lordship.
Media case number 455.
22, yes.
Where is 9/3/2003? It is not here. How will they allow this thing to go? Yes, 9/3. Summary money suit.
Yes, summary money suit. Yes. Some post-retirement beneficiary of my father. He used to work at Honorable High Court.
Appeal against what?
Against appeal, they made appeal against this order, 9th order. But
Appeal
also
was dismissed for
yes,
what?
dismissed on a
The
merit
appeal
also.
is not
Appeal is
maintainable.
not maintainable at all. Because it does not fall under the category of order 43.
Hello.
It's a no merit at all.
It is an application filed under section 115
Yes, 115.
of the Code of Civil Procedure 1908, challenging the order dated 9/3/2023 passed in media case number 455 of 2022, as well as the order dated 13/10/2023 passed in
Miscellaneous
appeal
appeal.
number 12 of 2015. From a perusal of the impugned order dated 9/3/2023 is that the respondent herein, respondent number 2 herein, filed an application taking impleadment in the stage 2 on the ground that the respondent number 2 is one of the legal representatives of late Bokanta Kumar Taluka,
Yes.
who was Taluka, whose retirement benefits the plaintiffs were seeking. The learned trial court, on the basis thereof, by order dated 9/3/2023, permitted the said impleadment. Being agreed, an appeal was prepared before the court of the civil judge, Senior Division number 3, Kamrup Metro at Guwahati, which was registered and numbered as Miss Appeal number 12 of 2023. The state appeal was dismissed on the ground of maintainability. It is under such circumstances was dismissed on the ground of maintainability or by an order dated 13/10/2023. It is under such circumstances both the orders dated 9/3/2022 23 and 13/10/2023 have been put to challenge in the instant proceedings. This court, having perused the order dated 9/3/2023, is of the opinion that the learned trial court did not commit any jurisdictional error. This court is also of the opinion that the said order the said order dated 9/3/2023 is not an appealable order within the ambit of Section 104 of the Code of Civil Procedure. Under such circumstances, the question of interference with the orders dated 9/3/2023 and 13/10/2023 does not arise, for which the instant petition therefore stands dismissed. There is no stay.
No,
No,
no, nothing.
I am appealing for
Respondent number 1.
respondent number 1.
Give your name.
Public.
23.
Yes.
Application
What
I
is this?
number 1821 for addition of party. The party has number 4 expired.
What is this application?
The application under order 1/2/10 my lord for addition of party.
Why?
My lord, what has happened? The respondent number 4 has expired. And but when my learned friend submitted the death certificate, it came to my knowledge that my lord, before filing of the second appeal and after filing of the my lord first appeal judgment, he has expired.
After
After the first appeal judgment,
he expired.
but before filing of the second appeal. That was my lord, the application for substitute for payment in the file is.
So you file the instant appeal against the dead person.
But at that point of time, no one was aware, man.
Huh?
When was aware, man?
Years left.
You are paying for whom?
For the respondent number 120, my lord.
120.
We issue notice.
They are the legal heirs of my lord, that respondent number 4. They are the sons, my lord, of respondent number 4.
Huh?
Respondent number 123, they are the sons of my lord, respondent number 4. Only the daughters be added. No,
Oh, dear daughter. They are already there. Why do you need all these things?
only son, my lord.
So,
But the other, but my lord,
no, respondent number 4,
Experiment.
estate is duly represented.
no, my lord, actually, there is 3 cell deeds, my lord. And one of the cell deeds is in the name of Jakubali.
So,
But that land is separate, my lord.
isn't his estate represented?
Yeah, by the son of.
So, can't the sons be there? Why do you need all these things there? It is required.
All the legal.
Why?
My lord, this question was asked to my friend. Why don't you represent? It's just I am only appearing for this person.
Ah. Why do you need all these people? Why?
There's a legal
There are many judgments of the Supreme Court when the estate is duly represented. Why is it required? Because Yukubali's estate is duly represented by 1, 2, and 3. They can come and file an I. It's a different thing.
And that actually what has happened in the suit, my lord. It is for cancellation of pre-settled, my lord. Three different properties. And one of the settled is in the name of only the Yakubali.
Therefore, whatever may be, Yaqub Ali's estate is being represented by 1, 2, and 3 also.
His daughter is also there. Daughter and wife also.
Are you appearing?
1 to 3.
Are you appearing for the others?
No.
Then don't say anything. I pass an order not necessary. But you want to appear for them?
No,
Then do it. This is an application filed under Order 1, Rule 10.2 for impleadment of the daughters of the respondent number 4 who expired after the judgment and decree passed by the First Appellate Court and before the filing of the appeal. This court have duly taken note of that the respondent number 1, 2, and 3 are the sons of the respondent number 4. And as such, as the estate of the respondent number 4 is duly represented by some of the legal representatives, the filing of the instant application is not necessary. Accordingly, the instant application stands closed as misconceived. It is, however, made clear that the instant order shall not preclude the daughters of the respondent number of the deceased respondent number 4 to file appropriate application if they seek impleadment in the instant appeal. Now, let's see, you are represented. What is the condonation? How much?
For delay of 590 days.
How much?
590 days.
91 days. What is the graph?
My lord,
When was the judgment delivered?
for the 35,016, my lord.
16. You filed. Why the matter has been so delayed? Why did you file it in 19?
My lord, part mistake is mine. Part mistake is mine.
Okay. You filed it on 23, 2019. Judgment was passed on 35, 2016. Why?
Well, actually, what has happened, my lord, like shifting when I was in my chamber, most of the documents got lost.
In 7 you go. Oh.
Paragraph 7 and 8. you have.
You got the copy. When did the applicant approach you? Because the judgment and decree was passed on 35/2016.
Got
And you came to know about this on 21/6/2016. And you got the certified copy on 16/7/2016. Then
So, but the applicant came to know on 24/12/2016, my lord.
Huh?
The applicant came to know on only on 24/12/2016, my lord,
24,
when he visited his advocate.
24?
No, no. 24/12/2016.
No. What is this? Kindly see, the certified copy of the judgment and was applied by the applicant's previous counsel on 21/6/2000 and for submission the same was ready for delivery on 14/7, which was received on 16/7. Then,
Yeah, advocate received the, my lord.
but could not. The applicant usually visits the counsel at Nagaon court to inquire about his case. However, because of his ill health, he could not visit the counsel to inquire about his case. Was able to visit his counsel and came to know about this case. Who was the applicant's counsel who applied
My lord,
for the certified copy?
my lord, Remand. Here,
Why did he apply for the certified copy? He shouldn't have applied for the certified copy.
his clerk, my lord,
Huh?
Hopefully his clerk applied.
Absolutely nobody applies. And you know how a certified copy is applied. You have to ask that person to get the decree made. Making a decree in the trial court is not so easy. They take a hell lot of time. After somehow managing to travel there, the applicant was able to visit Guwahati along with the counsel and about the matter with his current counsel that the current counsel informed the counsel that very much counsel they have to check the applicant complete on the first week of March, informed about the counsel have been on a period. Expenses required for the counsel started preparing the field. What papers you wanted?
The answer set of those papers that given for drafting, my lord.
What papers were submitted to you?
It's plain.
You didn't have the plaint. You didn't have the plaint.
No, my lord, the whole paper, my lord, mistake, my lord, by the changing my chamber, my lord, from
When was it misplaced? When did you shift?
around 2017. And
You can't say that. This is a very serious aspect. You can't say that. Somebody's case is going to go now. You can't say that you are taken like that. I am dismissing this application. And if I am dismissing this application and however giving the liberty to the applicant to take recourse to whatever proceedings can be done against you. It's absolutely this small country. There is nothing mentioned out there. He knew about it very well on 2016. And can it take for 1 year? Kindly see, into March 2017, he contacted you. Papers were given in the March 2017. There's no explanation, nothing. When did he give and handed over the papers? Only in June 2017. You know the period of limitation is 3 months. And then this can't be the manner in which you have to take it. No. This is an application under Section 5 of the Limitation Act.
my lord,
Sorry.
my lord,
I'm not going to.
let me pay some cost, my lord.
No.
He has also not filed any
Cost upon you.
on me.
1 lakh. 1 lakh. Then only the council will realize that You have to be responsible when you take their papers. No, Mr. Counsel,
I'm telling you the fact.
I am not going to do that because this petition has been very loosely drafted also. Sorry. Go to Supreme Court. I'm not going to do that.
Point of time also.
Absolutely, the cost will be 1 lakh because you have to understand, the councils have to know you are paying with somebody's life, somebody's property, because of the fact that he doesn't have money. You have taken it in. This is the reason why. He is a poor litigant, and as such, he could not collect the money. All along, you have been saying that, and then thereafter, you come up and say you have lost this file. How many other files have you lost?
This is the
Then
only because at that
why
point
this is
of
the
time,
pick and
my lord,
choose of this
my
file?
lord, may I submit, my lord? Maybe it's not there on record. Actually, at that point of time, my lord, my mother was very ill, and in fact, she.
That is,
expired also after 6
I'm
months,
not
my lord.
concerned with all these things are not here.
But let it be 50,000, my lord. I'll pay from my own pocket.
50,000.
But this is the only mistake, my lord, I have made in my entire career.
So
And I
then you
acknowledge that, my lord,
realize
in
for
this
all
petition.
time to come that these mistakes, if you make, because it is somebody's life and death, somebody's rights, making it as a. If he had paid you that money at that point of time, you would have immediately drafted the second appeal and filed it in 2017.
It is not that, my lord. Not
Yes.
because of the money. my
Because of the fact that, no, you had the papers. What prompted you? You had the papers on 31, 2017.
Well, actually, at that point of my mother had sick, my lord. I had to take her to for an operation.
There's
And after 6
nothing
months, she
mentioned to
expired.
that effect. You should have
I really
then,
forgot,
if you
my lord.
could
That is
not,
exactly
you
what
could have
I'm
asked
telling in the
somebody else.
application, my lord.
You could have asked
I'm not
somebody else.
hiding anything.
You could have asked somebody else. This is not the manner in which, because does it require for you to prepare a second appeal for 6 months? You lost the file sometime in the month of after June 2017. Then, because in June 2017, he could come to pay you the money.
Not that.
He paid you the money in June 2017. You say.
Well, money I will not talk because I know what he has paid me, my lord.
No, you say.
If along with the file, he has come.
Why did he have to
my lord.
collect the money?
Pardon?
Tell me, why did he at all have to collect the money? Tell me. If you have nothing to say about the money, then why did he have to at all collect the money as you have stated at paragraph number 7?
That is what he has told me, my lord.
If you don't ask, why will he collect? Tell me. No. This is an application under section 5. I'll condone the delay with 50,000 cost upon the count. This is an application under section 5 of the Limitation Act for condoning the delay of 591 days in preparing the accompanying second appeal. Against the judgment and decree dated 30/5/2016. Hey, when it comes to condonation application, why it was kept effective? What were the defects? Somebody's rights have accrued in 2016. 50,000 is too less. What defect the habit? No section is mentioned to be filed on donation petition. Ineligible portion of it. Appeal was filed on the year 12/4/2018. Now tell me, you filed the appeal on 12/4/2018. Why didn't you file the condonation application for 1 year? I hope you know that aspect, that a condonation will be required. The appeal was defective from 12/4/2018. Why? In paragraph number 7, you say that he has paid you the money. Thereupon, you lost the file. He gave you the file. You prepared the appeal. And then you say you filed the appeal on 12/4/2018 without a condonation. Yes, an appeal can be done without even filing the condonation then. But what did it take you to file this on 23/2019? Isn't this a serious case of negligence on your part? What did the Supreme Court hold recently on the misconduct of the council on consumer? Do you come under that nowadays? Supreme Court was hearing that pattern. Why your case should not be referred to the Bar Council for misconduct, apparent misconduct? And when did Yaqub Ali die?
2016. 30,
Huh?
36, 2016.
30?
6, 2016.
15?
16.
After the judgment.
After that.
Now, this is an application for condoning the delay of 591 days in filing the instant appeal, in the filing the accompanying appeal against the judgment and decree dated 30/5/2016, passed in title appeal number 2/2015, arising out title appeal number 2/2015 by the Court of the Additional District and Sessions Judge, FTC Nagaon. From a perusal of the materials on record, more particularly, from the perusal of the said application, more particularly from paragraph number 2 to paragraph number 6, it transpires that the earlier counsel who was representing the applicant did not inform immediately after the judgment was delivered on 30/5/2016. The earlier counsel informed the applicant only on 24/12/2016. It is further seen that the applicant thereupon, who did not have good financial backing, who was not of good financial condition, could come over to Guwahati and inform his counsel at Guwahati as to what steps could be taken. The counsel informed the applicant that in order to do so, inform the applicant that the applicant is required to file a second appeal. Along with an application seeking condonation of delay. The counsel for the applicant further informed the applicant as regards the expenses and the cost involved in preparing the said appeal. Under such circumstances, as the applicant did not have a good financial, was of poor economic condition, he went back to his native town and collected money. And in the month of March 2000, and in the month of March 2017, the money was collected and the papers were handed over in the month of June 2017 to the applicant, to the counsel for the applicant. Thereupon, it has been stated that the counsel for the applicant lost the papers on account of shifting. There is no affidavit, however, filed by the counsel for the applicant. And from a perusal of the affidavit, it is seen that the applicant does not know how to read or write, taking into account that he had only put his thumb impression in the affidavit. Thereupon, also, it further transpires that the counsel for the applicant, even after receipt of the fees, did not take any action and in fact forgot about the matter as has been stated in the application. The entire papers which the applicant was able to produce, give it to the counsel for the applicant, was also lost, for which the applicant again had to give another fresh set of papers. On 25/3/2018, thereupon the appeal was prepared and the appeal was filed on 12/4/2018. Not only that, this court also finds it very pertinent to observe that the counsel appearing on behalf of the applicant, who as from the certificate has a good length of service, a length of practice, though filed the appeal on 12/4/2018, but did not dare to file a condonation application till 23/2019 and kept the appeal pen in a defective state. This court, during the course of the hearing, inquired as to why such a step had been taken, why no steps have been taken. The counsel had no answer. Therefore, from the said application, it appears that it was on account of the mistakes of the earlier counsel who represented the applicant in the trial in the first appellate state, and it was on account of the negligence of the counsel who has filed the appeal. There has been this considerate delay of 591 days. Taking into account that it is on account of the mistakes made by counsels, this court is of the opinion that the delay, that the petitioner, that the applicant herein should not be penalized, for which this court condones the delay of 591 days. However, this court also opines, this court is of the opinion that such negligence or carelessness on the part of a counsel cannot be condoned. Inasmuch as the said would portray a very sorry state of affairs and send a wrong signal. Accordingly, this court imposes a cost of rupees 50,000 upon the counsel, Mr. A. Borkotogi, which is to be deposited by him before the registry of this court by 24th of April 2024. The counsel appearing on behalf of the respondent numbers 1, 2, and 3 would be at liberty to file an application before the registry of this court for release of the said amount. For the respondent, opposite party, number 1, 2, and 3 shall be at liberty for release of the amount so that the same can be sent to the opposite parties. The interlocutory application therefore stands allowed, subject to the cost, and the registry shall register the accompanying second appeal and list the matter at the stage of Order 41, Rule 26/24, Order 41, Rule 30/11 on 29th of April 2024. I stand. Yes, what is this?
Wait, with your lordship, this is a delay of automatic petition filed against the appeal preferred under the against the order passed by the administrative judge of December entitled to divorce case.
Issue notice making it returnable by 3rd of June 2024. steps be taken by way of registered as well as usual. Fine.
Can the date be post? Date be pre-post?
Yeah.
By 13th or 14th of
But you have to then take justice service.
April.
So what? You ask somebody to serve it. Notice making it returnable by 13th of May 2024. Steps be taken by way of justice service. Steps be taken by way of registered as well as usual by 9/4/2024. The petitioner, the applicant is further directed to take justice service upon the respondent by way of routed to the court and fine.
26.
What is this?
I got respondent number 2 died, but unfortunately there is delay by
Who died?
respondent number 2. His name is Mohammed Shaq Ali. I thought there is a mistake on his part, the appellant's part. He did not inform us. This person died on 5/12/2018. Only when the letter counsel for the respondent, number 1, had made the submission for the honorable court. Then we asked the appellant about it, and then he confirmed it, and the names were given, and thereafter it was signed. So as per the registry, the delay is 872 days. 870.
Who is paying for respondent number 3?
I appeared for respondent 1, man.
Who appears for 3? Second appeal of which year?
My lord, appeal of
18.
2018. Appeal is not yet admitted. Appeal is not yet.
What is your substantial question of law?
We have filed the amendment memo of the there, my lord, the grounds as well as the substantial question of law appears at page 7.
Page?
Page 7. Amendment.
No substantial question.
My lord, page.
Understood. None are substantial. So we dismiss it. Why you need to carry out this unnecessary matter ends? These are all questions of facts which have been already arrived at by the learned first appellate court. In the light of the evidence. Everything is in the light of that evidence. Evidence have been appreciated. Rightly or wrongly, it's an appreciation of evidence. How does it become a substantial question of law?
My lord, my lord, good.
Huh?
Good, my lord. Page
Ah.
page 40. number 3, my
First offered to sell the suit land to the plaintiff.
burden was on the defendant number 2 and 3. The court below have put the burden on me to prove that burden was not on. And in the cross-examination, they have said that there was no witness when
Who
such
said?
the defendant. Issue is, my lord, whether the defendant number 2 has first offered to sell the suit land to the plaintiff. Court below has said that
Has the plaintiff stated or not that they have offered?
no, but we have denied that.
You have denied it, said okay, but the plaintiff has stated or not?
My lord, there was no such offer.
Understood. That's a question of fact.
Yes.
The fact has been arrived at by the court.
That is the thing, my lord. The burden has been put on me. Whereas this two burden of proving this it was on the defendant number 3, not on me.
You are the?
I'm the plaintiff. My suit has been. I had filed the suit to exercise my right preemption. Defendant number 2 and 3 are my co-sharers. But they sold it without my consent to
To the defend number?
1.
Who is defend number 1?
Respondent 1.
Defend number 2 and 3 sold it.
They are the co-sharers. That's the joint.
Why they would sell it to you?
Because I'm a co-sharer.
How do you become a co-sharer?
I know my
Brother.
brother.
So you know about his death.
Yes, my lord. But
Then, on that ground, it has to be dismissed. Yes. Exchange of notice does not arise. You are his own brother.
my lord, that we have stated, my lord. Honestly, we have stated the fact. But it's true, my lord.
So we dismiss it on that ground. 872 days it cannot be. Understood. 1 year, 2 years is okay. But this is 872 days. It can't happen like this.
My
You
lord,
know it very well.
at page number 5,
You are very vigilant enough to exercise your right of preemption, but you are not vigilant enough that an appeal is pending.
my lord, inadvertently, we have stated page number 5, my lord. Fact, your lord, 51.
Hmm.
Thereafter, whatever your lordship said, okay, but that during the pendency of the second case being RSA number 1 of 2008, the response number 2, Mohammed Shah Ali is said to have expired on 5/12/2008. But though the petitioner was aware about the death of respondent number 2, but inadvertently failed to inform his counsel regarding the same. And it was only when the counsel for the respondent had informed the honorable.
Oh, the council has done their duty, but there has been a clear-cut negligence on his part.
My lord, inadvertent.
There can't be an inadvertent mistake for 872 days of not 880, 1590 days, actually. But on account of this COVID, you got this benefit, but they have not informed you, they have not met you.
My lord, it's not informed.
Then,
My lord, that is the thing, my lord. We had, like my senior had older than mine. Why they are not?
then
That has been already recorded, my lord. Order dated 9/5.
why didn't you correct the defects for almost 5 years?
My lord, the memo of the ground, the substantial question of law was there, my lord. But the ground was not mentioned.
What ground?
My lord, the ground. We had mentioned the substantial question of law. grounds was not there. Then the objection was raised. Right?
Where?
So we filed the amended amount of it. Then
The objection. When did you file the amended memo? The defect is this. This not on those substantial question of law. The defect is court fee of rupees 550 is paid. 5 rupees 50 paisa was paid. Annexure E is not mentioned in the underline in the plain and WS. These are the defects.
I thought, but later on, my lord, that after that the objection was raised.
There are many chances which were given to you. You corrected the defect after 5 years. Not a purpose for condoning. Now, whether the suit can survive, the appeal can survive without them, without the response number 2.
My lord, the thing is that the right of preemption, not just the way, my lord, that
So the sale which have been made
Right.
in favor of the defendant number 1 has been made by defendant number 2 and 3.
Right.
Now, defendant number 2 and 3, defendant number 2 does not remain. Then, isn't it a joint decree?
it is a joint decree, but my lord,
But the sale cannot be set aside. One sale cannot be set aside, the other sale cannot be set aside.
my lord, it is not about setting aside the sale. Sale is there. There is a valid sale. If this court decides in my favor, I will just step into the shoes of what that is.
How?
My lord, that is the right of preemption. But
The right of preemption, how is it? Was a sale being made? Defendant number 1 is not the owner. He's a purchaser. So his rights have already been accrued on the basis of the deeds of sale.
Right, right.
So how do you become the co-owner?
I'll not go over. I'll step into his shoes
How?
by way of preemption.
That they will say, they will have to sell it.
Yes, he will have to sell.
Understood. But the question arises, once the deed of sale,
Right.
which have been there
Right.
in their favor,
Right.
the moment I say it has abated,
Right.
the decree passed by the first appellate court against the respondent number 2 becomes final. If that is final, can I pass a decree later on as regards the respondent number 3? No. And thereby respondent number 1 goes away. So it is an inseverable decree. So the appeal goes. Isn't it? So Very good. At least the appeal finished. Isn't it?
Again, order is at 9/6/2020. It is also recorded that different respondency also expired as per the submission made by the learned counsel for that.
Respondent number 3 also expired.
It is also recorded now. In the order sheet, it is recorded on 9/6/2023.
9,
9/6/2023, my lord.
9/5/2023.
9/6, my lord.
9/6/2023 also respondent number 3 expired. Then what remains? Therefore, we dismiss this on the Baki books. Will be a more clear. This is an application under Section 5 of the Limitation Act 1963 for condonation of the delay of 872 days in preferring the application for setting aside the abatement of the appeal in respect to the respondent number 2 who expired on 5/12/2018. This court finds it very pertinent to observe from the materials on record that the appellant, who was the plaintiff, filed a suit being titled suit number 14/2010. You have not challenged the sale deed in his favor.
I cannot. The first thing, there has to be a valid state. I cannot challenge the state. I really have to step into its truth. He has to set it back on paying the price.
Understood. But there is a valid sale deed in his favor.
Then he transfers right. So his right could then get it.
That would be, but there is a registered sale deed.
Right.
There is a registered sale deed by defendant number 2 and 3 in his favor. So under such circumstances, there is a registered sale deed, but the sale deed has not been challenged. You see, the right of preemption, whatever it may be, yes, the Mohammedan have a right of preemption that if it is a co-sharer, the first opportunity has to be given to him. If you don't do it, then obviously that sale would be subject to the sale will be subject to the right of preemption. That's it. But then also the sale has to be put to challenge if there is a sale deed. Without an existing sale deed or till a sale deed remains in existence, nothing can be done. But it is because of the right of preemption, you have a right of challenging the. Huh? No, that is the law, if I am not wrong. Because as I was doing one matter pertaining to Radhabari Tea Company, it's reported. There, an interesting aspect came up. You see, in this memorandum of articles and associations of a private limited company, there's a right of preemption. First option has to be given to the existing shareholders to purchase the shares, and if they don't purchase it, then only you can sell it to somebody. That is, and while giving them the opportunity, you have to say that the third party is giving me this amount. . Now, if he exercises that, then it is okay. But if he does not exercise, or you don't give him an opportunity and sell, then he, on the basis of his right of preemption, can very well challenge the sale. But that sale will be therefore subject to his right of preemption. But merely because you have a right of preemption, his sale deed does not become bad. But that sale deed is being subject to, you have to challenge the sale.
Put that as the order.
Which one?
This point five, right? Point of law.
No, why should I now? This is not required for this purpose. This purpose, I'm only challenging, I'm saying this only for the purpose of touching on the inseverability of the decree. It is relevant to take note of that the appellant herein, being the plaintiff, had filed a suit claiming right of preemption and possession over a plot of land described in Schedule B to the plaintiff. And for other consequential reliefs. The cause of action for the filing of the said suit was that the defendant number 2 and 3, who are the respondent numbers 2 and 3 in the instant appeal, had transferred by way of sale, by registered deed of sale, the said Schedule B land in favor of the defendant number 1, bearing sale deed number 2088 dated 7/9/2009. Be it as it may, the said sale deed was not put to challenge in the said suit. In the perspective of the above, let this court now decide as to whether the delay of 872 days can be condoned. The plaintiff, oblique the appellant herein, as well as the defendant numbers 2 and 3, are all brothers, being sons of late Sahar Ali. The defendant number 2, that is the respondent number 2, expired on 5/12/2018. The applicant herein, applicant oblique the appellant herein, very well knew about the debt and did not take any steps till the filing of the instant application. It is the case of the applicant that, as could be seen from the application under Section 5, that when he informed that the applicant inadvertently failed to inform his counsel regarding the death of the respondent number 2. This, in my opinion, in the opinion of this court, cannot constitute a sufficient cause for condoning the delay of 872 days. Accordingly, the application seeking condonation of delay is therefore rejected এতিয়া এইখনত লিখিব এই দুখনত লিখিব হা এই দুখনত এই বুলি লিখিব that in view of the rejection of the application for condonation of delay by order dated আজি in IA civil number 31/2024 the instant application cannot be entertained being barred by limitation দুই ধৰণৰ হা দুখনত এতিয়া লেখক মেইন This court, by an order dated as it did, rejected the application for condonation of delay, being IA number so and so, substitution of setting aside the abatement of the response as against the respondent number 2, as well as for application seeking substitution of the legal representatives of the respondent number 2. Consequently, the instant appeal therefore abates as against the respondent number 2. This court further finds it relevant to take note of that by the order dated that on 9/6/2023, the counsel appearing on behalf of the appellant duly informed this court that the respondent number 3 had also expired. Therefore, there was no pursuant thereto, no steps was taken. At this stage, this court finds it very pertinent to take note of that the respondent number 2 and 3 jointly executed a deed of sale in favor of the respondent number 1. This deed of sale, although not specifically challenged, but the plaintiff sought for right of preemption and consequently the extinguishment of the right of the respondent number 1 on the ground that the sale deed could not have been executed. In view of the abatement of the against the respondent number 2 and 3, therefore, the decree which has been passed by the first appellate court is an inseverable decree. The abatement of the instant appeal as far as the respondent number 2 as well as the respondent number 3, therefore, renders the instant appeal renders the instant appeal to be abated as against the respondent number 1 else, and the appeal abated in toto. Accordingly, the instant appeal. Thank you.
Seven.
Yes, what is this? Huh?
Service has been completed.
Steps not completed.
Service has been completed.
Very well. Let's finish it off today. What is the order you are challenging? Order 6 Rule 17. What is the stage of the suit? What is the stage of the suit? Yes, yes. What is the stage of the suit?
Not ready.
No, no. What was the stage of the suit when the application was filed?
After filing of
Hello.
written statement.
None of the parties are aware at what stage the application under Order 6 Rule 17 is filed, taking into account the above, list the matter of the two. The court is not inclined to extend the interim order.
Your doctrine, this was the matter when documents heard in the last occasion.
Which one?
Where document on the 72nd day for ex parte evidence was given.
Oh, yes.
Document given a short date saying that take a service and thereafter will dispose of the next day.
You have filed it.
So what happened in between is that we have taken through registered post, we have taken mutual process, also the dusting, and what my client has told me, or they'll be afraid to go to the other side. If I think that they'll beat him up.
Where?
The-
Where is that?
No, I mean, affidavit we haven't filed. Over telephone, he has informed me. And he has sent some retired teacher, and they have denied. They did not. He personally did not know.
File that affidavit. File that affidavit. Whoever has gone there,
Yes.
file his affidavit. That's all.
So, not if that person will file who went.
Yes. Let him file the affidavit stating that I went there to give it. They did not.
So he's on the way today. He will come.
Okay. The learned counsel appearing on behalf of the petitioner submits that some time is required to file the dusty service, the affidavit for affecting dusty, taking into account the taking into account the above, list the matter again on
24th, the matter is fixed there for ex parte.
on 22nd of April. On 22nd of April. Interim order passed earlier shall continue.
Lord, actually, there was no interim.
There's no
Lord,
interim.
if gives an interim that I will be more than.
No, absolutely no. You then file it, they'll dispose it.
But if interim is very easy for the appearance, if they come, like it happened in
Mr. Counsel, I have in many cases, I have also appeared on the from that side.
Yes.
I know your eagerness will be there till you don't get anything. Yes.
29.
of like.
Yes, what is this?
May I please, Your Lordship, I filed this interim application. I am respondent here. And I have filed this application for vacating the order passed by this honorable court, that is at page 6, Your Lordship.
Page 6. What is that?
Your Lord, the appeal was under section 28 of Hindu Marriage Act, and while admitting the appeal, the court passed an order and restraining the petitioner to get married during pendency of the appeal. Now it is more than 1 year past, this appeal is pending for this court, and I want that order may be vacated.